So receiver has filed the report.
No. In item numbers 1 and 2, my lord, the receiver has, my lord, the visit has not yet been conducted.
Who's the
It
receiver?
is being scheduled, my lord, 2. Item 1, my lord, the learned receiver was here, my lord. She intimated me personally. She
Where
was
is
here
she?
before.
Where is she?
My lord,
So
then
in item 1, you are saying the receiver has not filed the report.
no, my lord. The visit is yet to be, my lord, conducted.
All right. 1 and 2.
1 and 2.
I am the receiver.
So you're seeking time in 1 and 2.
1 and 2.
2, I am the receiver in this matter.
Yes, madam.
Item number 2, I am
Yes.
the receiver.
So you have not gone
No,
to
they
the
have
site?
not sent, my lord.
It is yet to be, my lord, scheduled.
Yet to. Okay. So item 1 and 2, you need time. And what about 4, 5, 6, 7,
My
8,
lord,
9?
item 3, my lord, there was a direction to cause substitute a service, my lord. We have done so
All right.
in compliance of the order.
Take down item 1 and 2. Learned counsel for the petitioner states that he needs some more time to. You need time to. You
Madam?
need time for what? Item 1 and 2
My lord, further compliance, my lord, to schedule the visit of the learned receiver.
needs further time to comply with the directions passed by this court while order dated. What is the date of this? 6th August 2025. Full stop. Seeks and is granted further time of 2 weeks. 2 weeks? 2 weeks to comply with the directions given by the order dated 6th August 2025.
May I, my lord, on the safer side, may my lord keep this on the next monthly list? If it is conducted in between, it will, otherwise, my lord, it can be disposed of next monthly list.
Second, no. One more opportunity is granted to the receiver to take possession of the asset. Full stop. Liberty is granted to the petitioner to ensure that the receiver shall act in terms of the order, comma, failing which the receiver shall be discharged. Full stop. Let this matter appear in the monthly list of December 2025. Petitioner is directed to take steps for constitution of the arbitral tribunal immediately in accordance with law.
My lord, that part, my lord, has already been complied with. Section 21 notices have been issued.
It has been issued.
Section 21.
All right. Go through the last line. So then, what is the point of giving you so
My lord,
much
the
time?
difficulty is if the asset is located, my lord, the amount would be adjusted with the entire claim.
That's all right. That can be decided by your arbitrator also.
But my lord, gives one last opportunity, my lord. If the asset is not located, my lord, the item matters can be
See,
withdrawn.
if the arbitrator is already appointed, then you move before the arbitrator. What is the point of carrying forward this order?
My lord, the compliance of a section 17 order, my lord, would be, my lord, difficult to take possession of the asset, my lord.
Why?
It will be difficult, my lord.
But you can't use the court like this.
No, my lord.
If the tribunal is already appointed, you go before the tribunal, get an order
The
from
tribunal, my lord, a section 21 notice, my lord, has been issued, my lord. It is to be, my lord, followed by a
Not
section
yet.
11 application.
Last line, छोड़ दो फिर. The receiver shall file a report on the next date. List the matter after 3 weeks. No, list after 3 weeks. After 3 weeks.
My lord, in items 1, 2, 5, and 6, my lord, the same order can be passed.
1, 2, 5, and 6.
5 and 6.
Item 5. Your Lordship, I'm
Yes.
opposing that already appointment of arbitrator has been done. So, Your Lordship, they may move a section 17 application. Item 5. Ashok Yadav.
They're saying only notice has been issued.
Section 21 notices.
Yes, Your Lordship. Section 21 notice has been issued in this. Kholo.
Then you go before the arbitrator.
My lord,
What had fallen from Your Lordship, they may move the
the arbitrator has not been appointed.
Section 21 notice has
Notice has been issued. Go before the arbitrator.
Section 21 notice is to be followed by a section 11
It
proceeding.
will
my
take
lord.
some time.
If my landed friend is appearing for the respondent, my lord, she can undertake, my lord, to pay the outstanding due.
Why should I undertake? That is an adjudication that has to be done.
She
How
is
can-
appearing in a section 9 proceeding. Admittedly, dues are there.
Admitted
And
dues
now
are
she is
there. madam.
opposing a prayer.
Lordship, whether that are admitted or not, where that has to be, I have to take instructions
Give
and
a letter. It's good,
Take
my lord, that she
instruction
has
to come
appeared,
back.
my lord.
We can dispose it off.
Your Lordship, I am not giving any undertaking before Your Lordship because I have to take instructions on that because
You take
what
instruction.
instructions I have
Let her come back,
received
my lord.
is
Let her come back with
that,
this.
Madam, you take instruction.
I would
we
like
can
to
dispose
file
it
an
off.
affidavit in that case, Your Lordship.
What's the point of
Section
keeping all
9,
these?
madam.
Section 9, no affidavits. After 3 weeks, we'll keep it. If the arbitrator is appointed, if the receiver takes the possession of the property, it's fine. Otherwise, we'll see that. After 3
After-
weeks.
1 to 5, 6.
1, 2,
5 and 6. ma'am.
5 and 6.
Receiver, item number 6.
बताओ. With the earlier order. One, 2, 5, 6. Yes.
My lord, in item number 3, my lord, there was a direction upon the petition.
Item 3 then. Yes. What about item 3?
Item 3, my lord, there was a direction upon the petitioner, my lord, to cause substitute a service. My lord, that has been, my lord, effected.
Yeah, take down. Affidavit of service is taken on record. Full stop. The nobody appears for the respondent. The respondents, despite service, none appears for the respondent. Full stop. Paper publication was effected by way of abundant caution. Full stop. The order dated 19/2/2025 was passed in the absence of the respondents. Full stop. This court was of the prima facie view that there have been unpaid dues. Full stop. However, the court cannot comment on the quantum payable, which is a subject matter to be decided by the learned arbitrator. Full stop. Though an interim order was granted in this, right?
I believe not.
There is an interim order. There's an interim order.
Stand correct.
There's an injunction which has been granted by the injunction granted for restraining the respondents from alienating or transferring or dealing with the equipment prescribed in the order, namely, hydraulic excavator SY215 C6CZD full stop S-LC-9, serial number 20 SEY021E9 3031, situated at NH 27, Khatpara, West Bengal, and additionally, West Bengal, Khatpara, West Bengal. And additionally, the respondents were restrained from operating the bank account, the details of which are quoted below. यहाँ order से ले लो. Here. ठीक है. 19th February. This order has been served upon the respondent, but none had appeared on behalf of the respondent. Full stop. The jurisdiction clause has been placed before the court. Full stop. Under these circumstances, the interim order restraining the respondent from operating the bank account is confirmed and made absolute. Full stop. The said order will continue for a period of 1 month, 2 months.
My lord, 2 months.
2 months from the date. Full stop. Shall we appoint a receiver? Give a name of anybody. You give me a slip of all these young lawyers who are appearing here. Give me a slip of your name and your mobile number. We'll appoint one of you in these matters. Yes, young lady sitting at the back. Give your name and numbers to the court master. सुनिए, आप है ना court master?
হ্যাঁ আমি দিয়ে দিচ্ছি আমি দিয়েছি ফোন নাম্বার দিয়েছি ফোন নাম্বার দিয়ে দিচ্ছি
From the list, I'll appoint one of them. So Miss so and so is appointed as the receiver to take possession of the equipment, namely the hydraulic that excavator serial number so and so, situated in so and so. The learned receiver shall be entitled to a remuneration of rupees 50,000 apart from traveling cost and miscellaneous cost, which shall be paid in advance to the receiver. Full stop. A representative of the petitioner shall accompany the receiver and assist the receiver in the entire process. Full stop. The officer in charge of the concerned police station shall render all necessary assistance. The receiver shall file a report on the next date. The petitioner is directed to take immediate steps for the constitution of the. Have you served 21 notice? You have served it.
It forms part of the petition itself, my lord.
In this petition also,
Yes.
shall take all necessary steps for constitution of the arbitral tribunal. Full stop. Let this matter appear. When do you want this matter to appear?
It keeps it in the next monthly list or in the monthly list of January.
Same after 3 weeks. All these matters are the same. We'll dispose it off. There's no point keeping it.
Item 4, my lord, there was an order appointing a learned receiver, my lord. Remuneration has been paid, and my lord, I have instruction to my lord withdraw this matter.
Learned counsel for the petitioner seeks to withdraw the presented petitions in petitions. Seeks to withdraw the presented petition.
Item number
Petition dismissed in the trial.
Withdraw it. And take it. That's- My lord, 7, 8, and 9, my lord, receiver visit, my lord, has been conducted, my lord. They are to file the report.
I am the receiver, item number 7, my lord.
Yes, madam.
This is my report, my lord. এই যে হ্যাঁ অবশ্যই বলো না, বলো বলো দেখি রে। Item number 9.
So you have not been able to execute.
Yes, my lord.
You should have taken the necessary police help and all.
No, my lord, the asset was not found, my lord. That's why I did not go to the police station, my lord.
Yes.
My lord, this my lord adjourns it for 3 weeks because we will have to take further instruction, and as also I understand her remuneration is yet to be processed.
My lord,
So my lord, I cannot ask for her visit yet again without the remuneration being paid.
Remuneration?
As I understand, her remuneration is yet to be processed in this matter. So my lord, I cannot ask for a revisit, my lord, without paying her remuneration. Let me comply with that direction first, my lord, and then my lord, I will seek for further direction.
Already a report has been filed by the receiver. You are in all the matters?
no, not all.
Only in 7.
Only 7, my lord.
Report filed by the receiver is taken on record. Learned counsel for the petitioner states that the remuneration has not been. The report indicates that the receiver has not been able to trace the asset. Full stop. Full stop. Learned counsel for the petitioner states that the receiver has still not been paid the remuneration, and it will be unfair to expect the receiver to carry out the inspection without being paid the adequate remuneration again. Full stop. In view of the said fact, the learned counsel for the petitioner seeks 2 weeks time to take instruction. Let this matter be listed all together up. All these matters together on the same date, 1 to 10. After 3 weeks. Wait, let me see it. 8 and 9, nobody's there.
Yes, my lord.
You're
yes,
there.
my lord.
Yes,
But I am 8.
In 8. Yes,
8,
what
my
happened?
lord. My lord, I have visited the place, my lord, but
Yes.
I could not locate the asset, my lord. Report is ready, my lord, but it is given for typing, my lord. I shall file by tomorrow, my lord.
Learned counsel for the receiver seeks and is granted some more time to file report, though she orally indicates this court that she could not locate the asset. Full stop. उसके बाद भाई the learned counsel, you have been paid the remuneration.
Yes, ma'am.
Learned counsel for the, then what do we do?
My lord, keeps it after some time. Later file the report, my lord. We'll have to
My lord,
produce
I
the
shall file.
She prays क्या लिखा है? Learned counsel for the receiver. What other? She takes time to file the report. List after same 3 weeks. Yes, and
Yes, I'm item
9.
number 9.
Yes.
Yes.
What is there in item 9? Could you find the asset?
Yes, I find that, but could not police protection. I can do it. The petitioner could not arrange the police because the short notice due to the and heavy
Yes.
rainfall.
May I have a copy of the report, my lord?
Yes.
Report filed by the receiver is taken on record. The report indicates that the receiver could not take over the possession of the property since the respondent refused to cooperate. Full stop. She further states that the petitioner could not arrange for adequate police assistance due to short
The
notice
report
and
indicates, my lord, the receiver was probably, my lord, mishandled by the respondents.
sorry.
The
report, my lord, as indicates, the my lord, the receiver, learned receiver, my lord, was probably mishandled by the respondents, my lord.
Yes, my lord. They abuse me language.
It's always the case. It's nothing new. They will abuse. क्या लिखा है? take possession of the property. Yes.
She further states with the
Short notice and adverse weather condition, which an adverse weather condition, which did not allow her to take possession of the asset. Learned counsel for the petitioner states that she'll undertake another.
My lord, let me come back, my lord.
Learned counsel for
Whether
the
the-
petitioner at this stage
input and out. And what?
seeks time to take instruction from his client. Let this matter be listed after 3 weeks. But
I'm so grateful to my lord.
Grateful, my lord.
I'm so grateful.
yes,
My section 9 application, my lord. The
Yes.
receiver was appointed to take possession. She has taken possession, but she's to file a report. I'm been told that, my lord, she has some personal difficulty. She can do it on Thursday itself, my lord. The order is of 7th May 2025.
the
And she
30th
has to-
July order says the receiver has filed a report. The receiver is unable to take possession.
So that was the initial report, my lord. Thereafter, my lord, she has taken possession as we are aware of, but the report has to come forward before my lord. Whichever key. There was an order for extension of 30th July. Then, my lord, she has taken possession of. Where she was directed to, my lord, once again go and take possession, my lord. And the police to assist her.
30th July.
Thursday ki baar.
So we'll keep it after 1 week.
After one.
Learned counsel for the petitioner states that the receiver has taken possession of the asset, though she has not been able to file her report. Let this matter be listed after 2 weeks.
Grateful. Deeply.
This is my section 9 application, your lordship. Receiver was to file a report today.
My lord, I appear on
madam.
behalf of the respondent, my lord. My lord, post the receiver taking possession of the asset, there has been certain talks between the parties. Thereafter, they had suggested that we pay a sum of 18,68,149.
I don't have such instructions right
My
now, my lord.
The letter emails are there. I can share that. My lord.
I have no instructions from my advocate on record, my lord. These are directly to the company. I have to take instructions on this.
Take instruction.
My lord, only I seek
You have taken possession of this.
Taken possession of
6 crores, that's 80,000 lordship. 2 assets are not traceable and 1 asset is traceable lordship, that is Sally S500 lordship. Kindly come. That what rupees lordship? 6 crores, 2,40,180 rupees only. And I have taken the possession.
পরেরটা যেটা আগে ছিল তারপরে একটা You can keep it. How much?
So she has taken possession of the property.
My lord, may I
Settlement
suggest
there-
this? May I suggest this, my
Yes.
lord? They have handed a copy of an electronic mail of certain conversations. We don't have the formal instructions. Let this matter stand over for a week. We'll take instructions on the point of settlement, your lordship. And there has been an order of injunction. There are 3 assets, my lord. We had sought injunction of 2, out of which, my lord, 1 asset we have been able to trace and the others we have not been able to trace. There was an injunction. Let that also continue, my lord, for a week. Next week we'll come back, and if there is
What about
settlement,
the arbitration proceedings?
my lord, we have already invoked section 21 notice, my lord. Appointment of arbitrator is yet to be done. No appointment has been done.
Learned counsel for the respondent.
My lord, if one direction can be made, if a copy of the section 9 can be handed over, because on instructions, I'm saying this, the respondent got to know about this entire proceeding
Give a
on the
copy of
day.
the
We
section.
will, my lord. There was a substituted service also directed by.
Give another copy.
We'll
also.
hand over a copy. Yes, your lordship.
At the request of the parties, since some amicable settlement talks are underway, let this matter be listed after 2 weeks. Report is taken on record.
Grateful, your lordship. My lord, a copy of the report also be handed over to us, my lord.
You have given a copy of the report?
Great.
Lordship, this is my Section 9 application.
Yes.
Lordship, here we were directed, we had served upon them the copy of the application as well as the notice of motion.
Last time some settlement talks are going on. What happened?
Lordship, the settlement talks has failed and the parties are not yet ready to settle the matter. Your Lordship, they are not appearing in this matter as well.
They must have appeared last time. This order.
Lordship, there are no appearance from their end. We have duly served and the notice of motion is also there, Your Lordship. Kindly allows me to file it.
Yes.
Lordship, in this matter, they had taken a loan of. Lordship comes to. May I start, Your Lordship? Lordship comes to page 3 of my application, wherein paragraph 2, the respondent, the petitioner had provided, we had provided them with a loan of 10,21,995. Your Lordship, this was categorically guided by a loan agreement which contains an arbitration clause. Lordship, the arbitration clause, Lordship will find it at page 38, clause 26. Page 38, clause 26. Your Lordship, there is the arbitration clause. Your Lordship, categorically, this matter is absolutely guided by an arbitration proceeding. Lordship, in the meanwhile, we had tried our level best to amicably settle the matter and a loan recall notice. After that, Your Lordship, failing all these things, we have issued a loan recall notice, which is at page 53. If Your Lordship kindly comes to page 53, Annexure C, there is a loan recall notice, which is issued.
Yes.
Lordship, I'll be.
So why you are not invoking the arbitration proceedings?
Lordship, we are yet to invoke the arbitration proceeding. We were delayed because the settlement talks was going on between the parties, Your Lordship. We had time again given. Lordship, it was just to show our bona fide for them. There is no. We had given them enough room for them to repay the amount. We have given them enough room for them so that they repay their outstanding dues and take the account to such an they can restore the account or they can take their own measure. But they had not respected anything that has been provided from us bona fide. So, Your Lordship, without any further, I'll be carrying on with the arbitration proceeding and I'll be pressing on prayer A and B. I'll even apprise your lordship. Lordship, we had time again, went to them and verbally had a talk with them relating to the settlement. They were not even interested in that. These adamant attitude of theirs, I do not find any root of that. However, your lordship, every bona fide opportunities were given to them from our end, your lordship, without any other option. We are now pressing on prayer A and prayer B. Lordship, it is at page 9 of the application.
Take down. Despite service, none appears for the respondent. Full stop. This court is of the view that the respondents are avoiding service. Full stop. Learned counsel for the petitioner states that he has approached the respondents on many occasions and settlement talks were underway, which has resulted into nullity. Full stop. I'll attach the prayer B. I'll grant.
Lordship, I will please, if it pleases your lordship.
Learned counsel for the petitioner has drawn the attention of this court to the arbitration agreement between the parties, wherein the parties have subjected themselves to the arbitration proceedings. Full stop. Learned counsel for the petitioner states that he had issued a notice dated 20th January 2025 for return of the loan amount, which was duly sanctioned on 11. What is this? 20th 11. You write it in the American format.
Lordship, this loan recall notice.
No, that date. Loan agreement.
Loan agreement, your lordship.
2023.
23, your lordship.
So how can be 11/20, sir? American format.
Lordship, I'll just.
What is the date? What is the month? What is the year?
Lordship, it's 2011. Date of the loan agreement is 20th November 2023.
So how did you write it?
Lordship, where
Just see.
Lordship,
Page 53.
53.
So month comes first. You use American format.
Lordship,
Month comes first. The day comes
loan
next.
recall notice was.
The year comes later.
Lordship, the loan, I'll be very candid before your lordship. It was issued by somebody else.
No, this is issued by internet. Some app which you use. Nothing
Lordship,
else.
this is not me, your lordship. This is somebody else, advocate. Mr.
He's an Indian advocate. He's not
yes,
living in
lordship.
US. Stop using these
I'll direct the client.
online platforms. 20th November 2023. क्या लिखा है? Loan amount of rupees 1021995, which was duly sanctioned on 20th 11 2023. Full stop. Despite all the efforts, the petitioner has been unable to realize the loan issued to the respondent. Full stop. This court is prima facie of the view that the respondent is avoiding the services and that the petitioner is entitled to the interim relief as prayed for under section 9, whereby this court directs the attachment of the bank account of the respondent. What is the bank account details you have not given?
Lordship, we have not yet been able to trace out the bank account. So
You have to give me that. How can I pass an order?
Lordship kindly gives me another, 2 days time so that I can give the bank account, so Lordship. Lordship, because we have categorically stated and We have no bank accounts as
File
we
a
have not
affidavit
raised them.
then. Give me the bank detail account. Learned counsel for the petitioner seeks 1 week time to furnish the bank detail accounts of the respondent. Full stop. Let this matter be listed after 1 week. और किसको attach करोगे? Give the details so that we can pass an order.
Lordship, categorically will do that. Lordship, we had tried our level best to trace out. Your Lordship, if I fail,
In that is
Okay.
your duty. Can this court pass an order attaching any bank account?
Lordship,
You have
that is also true, Your Lordship.
You must have received the payment, at least one installment, 2 installments.
Lordship, that bank account stands closed right now, Your Lordship. I was intending to give that bank account only, but that stands closed as on date.
Find it out. Do your due diligence.
Much obliged, Your Lordship.
Your Lordship, on behalf of the petitioner, Your Lordship, on the last occasion, an injunction was granted in favor of, in our favor, prohibiting from creation of third-party interest over the property in context. Your Lordship, it was further directed to serve once again upon the respondents. This is the affidavit of service. It has been served upon respondent number 2 and 3, but it has not. There is a service upon respondent number 1 has come back. Your Lordship, this was in connection to a loan agreement, and the machine was bought in purchased with the loan. Amount which is due is 60 lakhs and odd. The property is in North 24 Parganas, Your Lordship. At this point of time, we were praying for an appointment of a receiver as well. On the last occasion, Your Lordship, it has been mentioned in the order as well to serve once again, and the point of appointment of receiver will be taken up at a later point of time.
Yes.
Yes.
You have been able to serve them.
Respondent number 2 and 3 has been served. Respondent number 1 is the name of the proprietorship firm which has come back returned. May I indicate that respondent number 2 is the co-borrower in the loan agreement, but is the sole proprietor. So respondent and 3 is also a party to the agreement as co-borrower. 2 and
Serve
3.
them again, sir.
We have 2 and 3 has received.
2 and 3 has received.
Yes,
Serve,
they have
respondent
received
number 1 again.
This is the third time we have served, so it is coming back.
Application.
Lordship, just one point, Your Lordship. Respondent number 2 is admittedly the sole proprietor. It is in page number 2. It has been stated. Page number 62. It is there. Sole proprietorship. So she is receiving the service, but the proprietorship concern in whose name who was a borrower in the agreement, that is not being able to be served. So since she is receiving, it can be deemed as a good service. That is my humble submission.
Can't be. Can't be. Learned counsel for the petitioner seeks and is granted further 2 weeks time to effect service upon respondent number 1, right?
Respondent number 1.
Respondent number 1. Full stop. Affidavit of service for respondent number 2 and 3, right?
2 and 3 are served.
2 and 3 is taken on record. Affidavit of service qua respondent number 2 and 3 is taken on record.
Grateful, Your Lordship.
List after 2 weeks.
Grateful, Your Lordship.
Instructions to appear. Vokalatnama formally is not executed yet. We can do it by today. I am otherwise ready to proceed with this.
There had been development agreement executed.
Before my learned senior friend commences his argument, we have a preliminary point of objection with regard to the very maintainability of the Section 9 application. I just indicate the preliminary objection. The Section 9 application is preceded by a suit plaint in which has been rejected. Where he has made statements, has filed plaint, made statements on the substance of dispute. Though we took out an application under Section 8 there, that has not been adjudicated upon. 7-11 we succeeded. So this is preceded by a suit. After having gone for a suit, whether he can say that, my lord, I will now go for arbitration, section 9. Though, my lord, the learned trial court has not, my lord, decided, adjudicated upon my section 8. This is, my lord, my preliminary.
Now, my lord, this arises out of a development agreement, my lord, which has been grossly breached by the respondent, supplemented, and after not taking a amount of rupees 1.25 crores, not he started inducting tenants and commercial establishments against consideration. So, not we filed a suit, no doubt, for the purpose of obtaining an injunction against this. The injunction was once made absolute after hearing the respondent, but then not on an application.
If you have approached the civil court, is it maintainable, this petition?
They have taken an application on the ground that the suit cannot be proceeded further because of a section 5 and 8 proceeding provision of the 1996 Act. Now, we challenged this order in appeal, the appeal got dismissed. So, as of today, the suit is not maintainable because of existence of arbitration clause. Now,
He's shaking his head. Yes.
Please come to page 142.
Just 1 second. Yeah.
Since I just definitely I just indicate 2 applications we filed, my lord, in trial court. One is under order 7 rule 11 saying that, my lord, the suit is otherwise also not maintainable. The second application was on section 5 reduced section 8 of the Arbitration Act saying that the parties should be relegated to arbitration. My lord, they used an objection to the 711 application. 711 application, my lord, was allowed on the ground that, my lord, he in his suit had not, my lord, prayed for specific performance of contract. So, my lord, section 34, my lord, only declaration, my lord, consequential reliefs not prayed. Section 34, specific relief act, plaintiff was rejected. He came up in appeal before the honorable division bench also, my lord, the plaintiff, my lord, stood rejected, my lord, the order impugned was not interfered with. So, my lord, he has gone for a suit without asking for specific performance. There, my lord, he fought tooth and nail my 711, filed an appeal, became unsuccessful there also. Now, my lord, he is saying that, my lord, let us go for arbitration so that, my lord, those disputes.
All those records are here.
Yes, my lord, he has
Page
disclosed.
146
Only
is his
plaintiff
application
is not
filed under section 8 of the Arbitration Act. Please have a look at page 146 in volume 2. The caption is the application filed under section 8 read with section 5 of the Act. Please turn over the page to 147. And the 4th line from the top. It is also an undeniable position of fact that the agreement executed on 7th November 1992 contained an arbitration clause providing for resolution of all the disputes arising therefrom through arbitration. But in this context, not he paid for. Please come to page 148.
Yes. Yes.
But in that context, not he paid for order 7 rule 11 as also. Please come to his prayer A at page 148. The parties to the present suit be relegated to arbitration for adjudication of all the disputes and differences carried in the suit. All further proceedings pertaining to the instant suit be stayed till disposal of the present application. Now, please.
What is the background to this?
There was a development agreement between the parties. His client has taken a sum of rupees 1.25 crores against me. Number 1. Number 2, the building got demolished and not all.
So you are the owner of the building?
I was the developer.
You were the developer?
He was the owner of the building. Now, as against receipt of 1.25 crores and also not for the entire expenses that my client had borne for the purpose of.
Given that 1.25 crores for, obviously you are the developer, so
Yes, the consideration was for every tenant that would be inducted in the building, he will be getting 1 rupee per square feet plus a 120 square feet office space. And not the tenant to be chosen by the developer or inducted by the developer. Now, also the cost for obtaining sanction plan for the purpose of reconstruction of the building once it got demolished by the KMC authorities. Now, that was done, not all process carried forward through my client. Now, he started inducting developers on the supplemental. This 1992 agreement was supplemented for quite some time till it fructified in 2016 and 2020. Now, thereafter he started inducting his tenants. Not we raised an objection, filed a suit. No, that's the outcome of the suit. The injunction application, once granted, was ultimately vacated. Hence, I am before your lordship praying for a restraint order on the respondent so as not to create third-party right through tenants or otherwise in commercial transaction for other parties in violation of this agreement. And we have also paid for inventory to a receiver. Please have a look at my prayers at page 25. A fit and proper person be appointed receiver, and the receiver be directed to do the following: 1, to take actual physical possession of the building; 2, to prepare the list of tenants already inducted in the building located at so and so; 3, to realize the rents from the tenants already inducted; 4, to induct new tenants in the new building located at so and so as per nomination made by the petitioner, and to issue rent receipts to such tenants; 5, to take adequate help. Now, please come to 6b. After 6b, an order of injunction restraining the respondent, their servants, from letting out, alienating, or transferring, or encumbering, or creating third-party interest by inducting new tenants in respect of the vacant portions of the building or in place and stead of existing tenants, against receipt of premium or salami or rent in any manner whatsoever until further orders of this honorable court, and an order of injunction from realizing rents from the existing tenants of the building in any manner whatsoever. But these are the twofold interim prayers that I have prayed for at this stage.
Where is your agreement?
But please come to the 1992 agreement, which was ultimately decided upon by the parties to be acted upon. Please come to page 34 straightway. But in the agreement, the
Clause 14.
yes, please have a look at clause 9 first and then 14. That the contractor of the one part is entitled and empowered to have selected the new tenants, and the landlord of the other part should accept them as tenants and issue the rent bills in their favor. So that's the primary condition of the agreement. And please come to 14. That all the disputes or differences arising between the parties hereto touching upon construction of any of the provisions of the presents or affecting the rights or arising out of or relating to these presents shall be referred to 2 arbitrators appointed by each parties. That is, each party shall apply 1 arbitrator, and in case of default shall be referred to the umpire appointed by the said arbitrators, and his decision shall be final and binding on all the parties in accordance with the Indian Arbitration Act.
Where's the clause for making the payment? Where have you made the payment? Where's the clause?
That 1.25 crores. Now, your lordship will be pleased to find that from page 60 and 61.
Page?
That kindly grants me only 1 minute's time. Page 55 is the payment, if I'm not wrong. Yes, please have a look at 55. That so and so being the landlord of so and so.
Page, sorry, sir.
Page 55, 55.
The declaration.
Declaration. That's so and so Kabir, son of so and so, being the landlord of so and so within the police station, received rupees 1 crore 25 lakhs from Zakaria Khan, son of so and so, as a personal loan apart from construction cost on several dates, which is appended herewith, and also declare that he can induct tenant in the premises with a power to collect rent from the intending tenants or occupants, and also receive amount, benefit, or profit with regard to transfer tenancy so and so. Now, this is the schedule of payment received. Comes to 1.25 crores.
This is not part of the arbitration proceeding.
Yes, please.
Read further, sir. If I fail to liquidate the same, Muhammad Zakaria Khan shall take all sorts of legal action, both civil and criminal, for recovery of his dues.
All costs, expenses, and
All
expenditure,
Yes.
including and without limitation to the that's not with regard to paying back. paying back the sum of rupees 1.25
That's the
crores.
whole idea, right?
The other part is induction of tenants.
If it's a partial, sir, you have to make this court understand. You are talking about a payment which you have received, 1.25 crores which you have received. The other is the terms of the agreement, wherein you were supposed to get 1 rupee per square feet for induction of any tenant.
He is supposed to get.
Obviously, you are supposed to pay him. That's what. Sorry, I was not that clear. I'll be more clear. So he was supposed to get 1 rupee, right? So as far as this payment is concerned, this doesn't fall part of the agreement which you have entered into, where there's an arbitration clause. It says that for recovery of your amount, you can take civil or criminal proceeding, whichever you want. So how does this fall part of the agreement as far as this is concerned?
Now, there are two parts of the agreement. One is, for the time being, let us set aside this 1.25 crores.
All right.
Now, the second part is induction of tenants apropos the development carried out by my client.
All right.
Now, please come to page 60. That's the supplementary agreement, which really is carrying forward the earlier agreement. It begins at page 58.
Page 50.
And the relevant portion would be at page 60.
Yes. Yes.
At clause G down below that, page 60.
Yes.
The present agreement is being executed supplementary to the original agreement of 92 between the parties, with a mind to clear up the ambiguities or differences or disputes, if any, that may arise at a future point of time.
Yes.
Please turn over the page to first clause on the next page. The party to the first part shall negotiate with the intending persons for demising or letting out the existing available space at such premium and rent as the party to the second part thinks fit and proper, and the party to the first part shall accede to the same at an agreed amount of rupee 1 per square feet as stipulated in agreement for development dated 7th November 1992. The developer contractor shall be solely entitled to demise or let out the existing FAR to the intending persons at the prevalent market rate or at such rate which the developer contractor considered to be just and proper. Similarly, apart from this 1.25 crores being representative of the loan amount, that
let us forget about 1.25 crores because that is a separate thing altogether. Let us concentrate on the 1 rupee which you are supposed to. Show me that there's a dispute regarding that and how they have not, or you have not paid, or you have paid but they are not really doing what they were supposed to do. Show me the violation.
Now, the pleadings are at paragraphs 13 and 14, with the evidence of rent bills being issued by the respondent. Paras 13 and 14
of your application.
Of my application. And it's page 8 of my application, paragraph 13.
Tenants.
But ultimately, the construction of the building was completed in the year 2016, and the petitioner started inducting tenants in some portions of the newly constructed building, and as the constituted attorney of the respondent used to issue rent bills to the newly inducted tenants. Copies of the rent bills by the petitioner on behalf of the respondent to the newly inducted tenants are annexed. It is noteworthy that the old structure standing at the said property was an old dilapidated building more than 150 years old. The petitioner and/or the associates or family members were tenants in occupation of a major portion of the said old existing building. In the year 2008, the Kolkata Municipal Corporation issued notice under 411(2) of the KMC Act urging the inmates of the said old building to vacate the same, since the same was in dangerous and ruinous condition. Pursuant thereto, the entirety of the building was vacated and the petitioner commenced construction of the new building at the said property in accordance with the sanction plan obtained from the KMC. The entire construction and all other related expenses like obtaining sanction plan from the concerned department of KMC and subsequent regularization was incurred by the petitioner out of his own pocket, and the petitioner craves leave to refer to the relevant documents. The next sentence, the petitioner further craves leave to produce the relevant documents. In the year 2020, in utter violation of the terms stipulated in all the aforesaid agreements, the respondent started inducting tenants in various portions of the newly constructed area of the newly constructed buildings at the said property without taking consent or even intimating the petitioner. The respondent started inducting new tenants after accepting huge premium or salami from such tenants. In addition to the above, the respondent and his men, in sharp derogation to the agreement or arrangement between the parties were obstructing or restraining the petitioner from inducting new tenants in the said newly constructed building at the said property, although the respondent had no right to induct such tenants and or collect any amount from such tenants in the form of salami or rent in any manner whatsoever in any portion of the newly constructed building at the said property, but the respondent continued to do so.
May I come back in a minute? May I come back in a minute?
Yes.
I'm not. I have also named some of the tenants, the names which I have been able to gather, which the respondent has inducted as tenants at paragraph 33.
Yes.
And may I place that particular paragraph?
Mayuk Khetan and Golu Hassan, alias Golu and Hassan Khan.
My lords.
Yes.
I'm not, because of the situation, we don't have access to the premises for the time being. That's why I'm not. It's also pleaded in the application, but in the arbitration, what we shall be seeking for is also the cost of construction vis-a-vis the expenses incurred.
Where is the right to induct the tenants?
Paragraph. Okay. Oh, no, that's in page 60. Lordship may straightway come to that page 61.
Page 61.
Page 61.
Yes.
The first paragraph, the first clause on that page. The party to the first part shall negotiate with the intending persons for demising or letting out the existing available space at such premium and rent as the party to the second part thinks fit and proper, and the party to the first part shall accede to the same at an agreed amount of ₹1 per square feet as stipulated in agreement for development dated 7th November 92. The developer contractor shall be solely entitled to demise or let out the existing FAR to the intending persons at the prevalent market rate or at such rate which the developer contractor considered to be just and proper.
So where are the list of tenants which have been inducted by them? A separate list of tenants? Only on, in one paragraph, you have mentioned two
Yes, no,
names
that's
of-
not the some of the instances that I have got.
You have to show the breach of the contract.
No, they have been inducted behind my back.
Who are those tenants who have been inducted behind your back?
Yes, not paragraph 33.
Only two you have mentioned. And they are saying that those were the old tenants and new tenants have come in their place.
They are the new. Please come to paragraph 33 once again. Not the third sentence of that particular, the second sentence of that
Brother to Mayur Khaitan.
is the apprehension of the petitioner rises particularly in view of the fact
To Chandan Shaw. These are the two names which
Mayur Khaitan, alias Gulu, Hassan Khan to Chandan Shah Prakash, and various other persons in above precincts. These are the two names that I have shown as an instance of new tenants being inducted in places of the old ones.
Nothing is stopping them from inducting new tenants from the contract.
Yes, if your lordship will kindly have a look at. Please come to the original agreement once again.
Yes.
Page 52.
Page 52 is the subsequent one.
The first one, the 1992 one, which was supplemented. Clause 3 at page 52. 52 though, right? Maybe 32. I'm sorry. I'm sorry, it's wrongly paginated. Not the
first one is page
32. 32.
Yes, 32.
Yes.
That's what I'm saying. So
Please come to page 33.
Page 33.
Yes. Paragraph 6 at page 33. That the landlord of the other part shall get and is entitled to get rent at the rate of ₹1 per square feet in average from the new tenants, and the contractor of the one part will arrange for that. That the contractor of one part will be allowed to construct nothing on the roof of the top floor except 10 by 12 room to be allotted to the landlord of the other part for office and maintenance purposes of the landlord.
So you're not able to make out any case for an interim order, sir. You have to tell me what is the violation.
Not this induction of tenants, not behind my back.
The induction of tenant also you have to show that they are not entitled to. They can induct tenants. Where is it? Where does your agreement read?
But please come to 34 clause 9 that the contractor of the other part of the one part is entitled and empowered to have selected.
Yes, you are you can also do it. They can also do it.
And the landlord should accept them as tenants and issue the rent bills in their favor.
That's right. But where's the restraint that they can't induct tenants?
Page 61 shall be solely entitled. Clause 2.
But if your lordships will once again come back to page 61, clause 2,
Yes.
the contractor shall be solely entitled to let out the existing FAR to the intending persons at prevalent market rate.
This is a subsequent agreement.
That's the agreement which has been supplemented and being acted upon.
That's right. You have a right. This right you also have. Even in the first agreement.
But this right is being breached with impunity, and not so far as the respondent is concerned, inducting fresh tenants behind my back, and I don't have access presently to that premises. Paragraph 33 being the names of the two inductees, co-tenants, not in the same premises.
Yes. I don't see anything. Yes.
And the three documents my learned senior friend Milord is relying upon. One is Milord a document of 1992, then comes Milord a declaration, and then comes Milord a 2016 agreement. Milord, the arbitration clause is there only in the 1992 agreement. 2016 agreement though says that Milord, this is supplementing 1992 agreement. Milord, there is no reference Milord to the arbitration clause contained in the 1992 agreement.
But how
Milord,
can you take that stand today? You are moving section 8
Milord,
application.
I come to that. I come to that also. So, Milord, doctrine of Milord incorporation by specific reference Milord would apply. Milord, if I go by Milord the definition of arbitration agreement in section 7, Milord, then it says Milord, there has to be Milord an incorporation by a specific reference in some other document. Milord, section 8 application, Milord, we did not move, it was filed, true. But Milord, there was a separate 711 application as well. Milord, occasion did not arise for us, Milord, to move section 8 application.
They can't go remediless, right?
That's true. That's true.
You can't blow hot and cold at the same time.
That is true. That is true. But Milord, section 8 not moved. Now, Milord, kindly come to 711 order, which Milord, my learned friend senior friend has not shown to your lordship. Kindly turn to Milord the order by which Milord the plaint was rejected. Milord, the order appears at page 165, second volume.
161.
65, Milord, second volume. It starts at page 165.
Yes.
Milord, kindly turn to Milord page 166, last paragraph. On the basis of Milord place, such allegations contained in the plaintiff has claimed a decree for declaration to the effect that agreements of 92 and 2016 are still subsisting. Did not get that decree. The plaintiff has also claimed a decree for declaration to the effect that the said agreements would remain valid and subsisting till the loan allegedly availed by the defendant is recovered. The plaintiff has further claimed a declaration that the plaintiff is entitled to continue to occupy the premises. Kindly see, today Milord, my learned senior friend was submitting, he has no access. Kindly see, Milord, what was Milord submitted before the learned trial court. Is entitled to continue to occupy the premises, which is why Milord, the plaintiff is not annexed here. The premises till recovery of the alleged loan. The plaintiff has claimed to have spent an amount of, now Milord, it comes to 2.5 instead of 1.25 for undertaking the work of construction on the property concerned, and has claimed a declaration of his alleged right to occupy the suit property till recovery of 2.50 crore from the tenants occupiers. Several other consequential reliefs have also been claimed in the suit. Then Milord, kindly skip over one paragraph, or Milord, let us kindly read this paragraph also. It appears that though the instant suit is founded on an allegation of breach of contractual terms, the plaintiff has omitted to claim specific performance of the contract in the suit. Milord, the relief, Milord, which he is really asking for is in the nature of specific performance. He is alleging breach. So he must show that he has, Milord, conformed to, Milord, the terms of the contract. I will show, Milord, multiple breaches by him. The defendant has submitted that due to such conscious omission on the part of the plaintiff to claim specific performance, the suit is palpably barred by law as a prayer in the form of a decree for declaration. Milord, he did not intentionally, Milord, ask for specific performance because he was in breach. He ought to have pleaded that, Milord, he has performed and he is ready and willing to perform. He could not have pleaded that, which is why he avoided that. Said that, Milord, I am in occupation, let me continue with the occupation. Milord, contrary to what is being submitted today before your lordship, that, Milord, they have lost access. Then, Milord, third paragraph. The plaintiff has also not disclosed in the plaint the amount so far realized. Kindly, Milord, appreciate the situation. 1992. Milord, 8 and 25, 33 years, Milord, has gone by. Milord, what is the amount they themselves have realized? They did not disclose there, nor are they disclosing here before your lordship. 1.25 crore, Milord, they are making a hue and cry, which is a separate agreement altogether, nothing to do with construction. That's a personal loan. That's what the document says. And they are not disclosing what is the amount that they have so far realized, which must have been, Milord, much in excess of even 1.25. Holding on to the property for, Milord, 33 years. The plaintiff has also not disclosed in the plaint the amount so far realized by the plaintiff from the tenants or occupiers. It has not been alleged anywhere in the plaint that since execution of the agreement in 1992, the plaintiff did not recover or realize any amount from any of the tenant or occupier. Learned Court asks them, you disclose, Milord, that was never. The defendant has submitted that on account of such omission on the part of the plaintiff, the plaint palpably suffers from non-disclosure of cause of action and resultantly plaint cannot be sustained. The defendant has submitted that the instant suit is also otherwise void in law on account of omission on the part of the plaintiff to claim any money. Milord, had this money been payable, he would have definitely, Milord, claimed that, Milord, in the suit. That was also not claimed because, Milord, they know that, Milord, if the account is, Milord, today directed to be disclosed, they would not be able, Milord, to show that. So, Milord, they file a suit. Milord don't, Milord, pray for specific performance of contract, nor praise for, Milord, recovery of money. And today, Milord, their principal allegation is 1.25 crore.
No, the principal allegation is that
I am inducting tenant. Milord, I am coming to that.
he has given up 1.25 crores.
Very well. Then, Milord, this application is all the more bad. Milord, because of their averments in this application, Milord, I will take your lordship to that. Let us, Milord, finish this order first, Milord.
Yes.
Since the present suit is based on sole allegation of breach of the terms of contract by the defendant, the plaintiff ought to have necessarily made a prayer for specific performance. By the reason of failure, suit is barred by law. Section 34. Defendant has submitted that had such a prayer been made, the value of such relief would have been excess in etc. Milord, I am skipping over that portion. Defendant has also contended, these are, Milord, my submissions, Milord, with regard to the jurisdiction of the learned court. Then, Milord, from a careful scrutiny of the agreement, it would also appear nowhere in the said contract any reference has been made to any alleged loan transaction, which has also fallen from your lordship, to the suit as averred in the plaint and as contended in the subsequent contract. Defendant has claimed that from such stark and glaring inconsistencies, it becomes clear that the suit is utterly vexatious. The defendant has submitted, etc. Then, Milord, kindly take, Milord, last paragraph. In the light of above, having heard the learned advocates at full length and after carefully perusing, I am of the considered opinion that the instant suit appears from the statements in the plaint to be barred by law. Consequently, I am inclined to allow this application. 711 is allowed. From that, Milord, appeal was preferred, Milord, before the Honorable Division Bench. Milord, the order passed by the Honorable Milord, Appellate Court is at page 171. Paragraph 4, Milord, is important at page 172. And, Milord, this trial court order, Milord, was passed on 26th March 2025. Milord, the Honorable Division Bench, Milord, passed the order in appeal, Milord, on 30th April 2025. Milord, more than 6 months has passed by. No intention even shown, Milord, to go to arbitration. Till date. It's just to, Milord, put a pressure, Milord, on me that, Milord, a receiver is appointed so that, Milord, I can, Milord, dance to his tunes. No proof that, Milord, how much money he has recovered. No proof what he has done, Milord, for 33 long years. No claim for money, Milord, before the learned trial court. No claim for specific performance of contract saying that, Milord, he is ready and willing to perform the contract. No intention shown, no manifest intention shown for this long year, Milord, to go for arbitration. All of a sudden, Milord, section 9. Milord, now kindly have a look at the averments made in section 9. Kindly turn to, Milord, page 40, paragraph 41 of this application. At, Milord, page 18. From, may I, Milord, place paragraph 41. From reliable sources, the petitioner has learnt that the respondent is in the process of letting out, alienating, transferring, creating third-party interest, just a mere bold statement, in respect of vacant portions of the newly constructed building at the said property by inducting new tenants. It's not his case that, my lord, he has made negotiations, my lord, he has tried to, my lord, catch hold of a tenant. He says, my lord, property is lying vacant, several portions. And, my lord, I am trying to induct tenant. Bold assertion without saying that what he has done, my lord, for inducting a tenant. Moreover, in breach of the agreement between the parties, the respondent is also realizing full rents from the tenants already inducted by the respondent to the exclusion of the petitioners. As a consequence of such illegal acts on the part of the respondent, this is, my lord, important. The petitioner is suffering loss and is not in a position to recover the cost of construction and also, my lord, the money paid as a personal loan. My lord, that is, my lord, his basis. Now, my lord, kindly see the agreement that contained the arbitration clause. Kindly, my lord, turn to, my lord, the agreement starts at page 30. Kindly, my lord, turn to page 34. My learned senior friend, my lord, has shown your lordship, my lord, clause.
That is the first agreement. What is the date of the first agreement?
This is sometime in 2016.
No.
I'll just indicate. Well, 7th November 1992. "33 years back.
Yes. What are you showing?
Page 34, my lord, continuation of that agreement of 1992.
Yes.
Clause 9, my learned senior friend has shown to your lordship. What is not shown, my lord, is clause 12. 1992, the idea was, my lord, he will complete the construction within 2 years.
Yes.
And, my lord, that agreement contained the arbitration clause. Nothing disclosed, my lord, on oath in this application even. My lord, what they did for those 2 years. Then came, my lord, the 2016 agreement and, my lord, the declaration. Kindly come to, my lord, now the 2016 agreement at page 58.
Yes.
My lord, kindly take clause F at page 60. Because, my lord, he is giving up, my lord, 1.25. I am not placing, my lord, the previous clause. 1.25, my lord, is dealt with in the previous clause. Since that is given up, my lord, I am not, my lord, dealing with that. Clause F at page 60. It was also agreed upon by and between the parties that the contractor would be entitled and empowered to receive, get and realize the cost of construction by inducting new tenants from time to time, for which landlord would have no objection and the landlord would be entitled to 1.30 per square feet in average from the newly inducted tenant. My lord, may I pause here for a moment? My lord, he does not disclose the tenants whom, my lord, he have inducted. The quantum he has realized does not even show that, my lord, out of that 1.30 million was to be paid to me. That was paid, my lord, by him to me at any point of time. Per square feet in average from the newly inducted tenant, and he is further entitled to get possession of an office room on the top floor. Then, my lord G, the present agreement is being executed supplementary to the original agreement between the parties in mind to clear up the ambiguities. So, my lord, if there is some differences, my lord, between, my lord, the parent agreement and the supplementary agreement, my lord, the terms of the parent agreement will be there. This is only supplementing, not, my lord, contradicting or altering. Then, my lord, kindly take clause 1 at page 61.
Clause
1. My lord, I was showing, my lord, the recital portion.
Yes.
Then, my lord, the habendum starts, my lord, at page 61. Clause 1 of the, my lord, habendum part at page 61.
Yes.
The part, may I, my lord, please? Party to the first part shall negotiate with the intending. My lord, he is the first part. With the intending, my lord, I'll just check, my lord, was first part. Yes, my lord, I was the party of the first part, party to the first part. It was me. Party to the first part shall negotiate with the intending persons for demising or letting out the existing available space at such premium and rent as the party to the second part made them fit, and the party to the first part shall accede to the same request at an agreed amount of 1 rupee per square feet. So, my lord, again here, my lord, I was entitled to something from the tenants. My lord, the rent receipts that my lord he has disclosed, kindly come to my lord page 64 onwards.
64.
Yes, my lord. Kindly take 65. 64 does not bear any signature, my lord, at least my lord, subject to correction. I do not find any.
Yes.
65 onwards. Document of 2015. Kindly see, my lord, who is, my lord, realizing the rent? Whose signature is there? It's him. And that goes on. And he doesn't show that he has paid, my lord, any penny, my lord, out of that, my lord, to me. So he holds on to my property for 33 years, merely go on, my lord, extracting money, does not, my lord, pay me anything, suffers a defeat in a suit, suffers in appeal, a defeat in appeal, then, my lord, shows no intention to go for arbitration. My lord, tried to, my lord, mislead the learned court, my lord, by saying that, my lord, that declaration is also part of that agreement, which is not. Application is based, my lord, on the assertion that, my lord, this 1.25, my lord, I am entitled by, my lord, recovering rent from the tenants, which is absolutely incorrect a statement. And then, my lord, this section 9 application without annexing the plaint. So, my lord, this gentleman, my lord, with due respect, my lord, to the person, my lord, does not, my lord, appear to be, my lord, honest to this honorable court. My lord, this and once, my lord, kindly also appreciate the situation. He had given up, my lord, his prayer for specific performance. He had given up, my lord, his prayer for claiming, my lord, recovery of money. My lord, order to rule 2 would come in.
Yes.
My lord, principle of constructive res judicata would come in. My lord, he is debarred by law for all time to come, my lord, to claim these reliefs. So today, my lord, arbitration he cannot ask for, my lord, showing firstly, my lord, the declaration, secondly, my lord, praying for these reliefs, and my lord, these agreements are then, my lord, unstamped. My lord, we have, my lord, a 3 judges bench decision, my lord, Justice Ashim Kumar Banerjee, Justice
But you're
Sanjeev
not-
Banerjee, and the Honorable Justice
You're
Arijit
not
Banerjee.
denying these agreements.
True.
You're
Section
not
9.
denying
True.
these agreements.
True.
Yes, sir.
Not my
For
knowledge.
averments, as far as the induction of the tenants are concerned and the violation of the contract is concerned, you have
My
not
lords.
placed any material on record to show reliable sources are not enough for this court to grant you any relief. All right,
That's one.
that's
Paragraph 33 is all that I have been able to show before your lordship or
Only-
demonstrate before your lordship as of today.
correct.
Now, I'm not 33.
And even in terms of the receipts which you have put, you are the one who's granting the relief.
Please come to the name of the respondent vis-a-vis the receipt.
The receipts are there.
Abdul Kabir's receipt.
That's
was-
right. But
Because in view of page,
an agreement which has been entered into 92,
Please.
then subsequently altered in or
because the new building came up after 2016.
2016, and then you are coming to this court without even invoking the arbitration proceedings, even after passing of the order by this very court in April, 25th of April, 6 months. Why should this court
No, not
entertain
so far
this?
as section 9 is concerned, your lordship, the law is too well settled, but the apprehension, not if it is imminent, not your lordship can concern. Please have not, as regards not the 33 years non.
What is the apprehension? You have not been able to make out the apprehension, sir.
Now, please come to page 59 once, not as regards non-receipt of rent by the respondent is concerned, vis-a-vis the same having been obtained by my client. Please come to clause E, page 59. That somebody gets 1.25 crores, then 2.5 crores rupees I spent for the purpose of constructing a new building. Please come to page 59. It was inter alia stipulated in the said agreement that the contractor would be entitled and empowered to construct or erect the new building and would bear all the construction, including other incidental expenses such as cost of sanctioning, settlement with the tenants and occupants, arranging the shifting of the lawful occupants to alternative places, it was also agreed by and between the parties that the party of the second part shall have the right to induct tenant and collect rent from the tenants and occupants as per his choice. The party of the first part shall have no right to interfere into the matter till realization of amount of rupees 1.25
Very
crores.
good. You should have filed a specific
No,
performance.
no, so far that is concerned, that my learned friend was vociferously submitting that for 33 years I have obtained rent from the tenants and without giving him a farthing. No, that's untrue on the face of it, the records. Number two, comes the question of a new building having been constructed in after 2016 sanction plan was obtained, which was completed in 2020, and he started inducting tenants behind my back in violation of the agreement, which he relies on by saying that there is an arbitration clause in the agreement. He cannot blow hot and cold, as it fell from the bench a few minutes back. He has to either say that there is an arbitration clause disabling me from my lord. So whether section 9 conditions are satisfied or not, that's not for your lordship's kind conscience to be satisfied, of course, no doubt about that.
But you should help me in satisfying those conditions.
Yes, but of course, that's the point. Paragraph 33 and 44, these are the two paragraphs I have been able to show apropos my right to induct tenants and the disability of the landlord to induct tenants behind my back.
Yes. What else?
These are my submissions.
The petitioner has preferred the present application under section 9 of the Arbitration and Conciliation Act 1996. Full stop. It is the case of the petitioner that the respondents have violated the terms of the agreement entered into between the parties. Terms of the agreement dated 7th November 1992 entered between the party. Full stop. Learned counsel for the petitioner had drawn the attention of this court to the fact that the petitioner had given an amount of rupees 1 crore 25 lakhs to the respondent as a personal loan apart from the construction cost. Full stop. The petitioner states that the said loan has not been repaid by the respondent. Full stop. The fact that the loan was granted to the petitioner in his personal capacity and does not form a part of the agreement entered into between the parties is evident from the record. Full stop. Learned counsel for the petitioner further states that the learned counsel for the petitioner agrees to the said submission that the said loan was advanced to the petitioner in his personal capacity and does not form part of the alleged does not form part of the agreement which is alleged to have been breached. Full stop. Learned counsel for the petitioner, senior counsel for the petitioner, states that the respondent has breached clause 6 of the agreement dated 7th of November 1992, wherein the landlord is entitled to get rent of rupees 1 lakh per square feet in average from the new tenants, is entitled to get rupees 1 per in average from the new tenants, and the contractor was one of the one part will arrange for that, and the contractor of the one part will arrange for that. He states that the respondent have inducted new tenants without his permission, and the amount so realized from the induction of the said tenants were never paid to the petitioner. Full stop. Anything else? I think these are your submissions. Anything else?
No.
Learned senior counsel for the respondent.
But I am not, my lord. I'm not designated. Well,
you are
senior,
not.
I'm not a senior.
Learned counsel for the respondent. Learned counsel for the respondent. Sorry, Mr.
Siddhartha Banerjee.
Mr. Siddhartha Banerjee states that the present dispute relates to the year 1992, almost 1992, full stop. He states that the petitioner had filed a suit before the Learned City Civil Court, title suit number 608 of 2020, full stop, wherein the petitioner claims to continue to occupy the premises, the newly constructed premises, till the alleged recovery of the loan. Learned counsel for the respondent has further drawn the attention of this court to the order passed by the City Civil Court dated 26/3/2025, wherein the plaintiff had recorded that the plaintiffs had failed to disclose the amount realized from the tenant or the occupier. As claimed in terms of the breach of the contract agreement dated 7th November 1992. Full stop. Learned counsel for the respondent had further stated that the petitioner had failed to invoke specific performance of the agreement dated 7th November 1992 and has been sitting tightly over the same for almost 33 years. Full stop. Though the trial court had disposed of the suit in terms of the arbitration clause which was provided in the agreement. Full stop. The said order was further carried in FAT 169 of 2025, which was disposed of on April 30, 2025, wherein the court had refused to interfere with the impugned judgment as Section 34 of the Arbitration Act was refused to interfere with the said judgment. नहीं वो छोड़ दो, refused to interfere with the said judgment. Full stop. Learned counsel for the respondent had further pointed out that the petitioner in the present application has failed to show any tenant who has been inducted in the property, and the application itself mentions that the petitioner on a hearsay the petitioner from reliable sources has come to know that the respondents are inducting tenants. Though the application has indicated 2 tenants which have been inducted which are claimed to be inducted by the respondent, but any supporting documents have not been placed on record. Full stop. On a mere apprehension, it cannot be on a mere apprehension that the respondents are inducting new tenants. The respondent states that the present application shall be dismissed and is not liable to be entertained. Anything else? This court has heard the argument advanced by the counsel for the parties. Full stop. It is from the application, it is itself evident that the petitioner has been unable to satisfy this court that the new tenants have been inducted, since the said facts have not been placed on record. It is further noted that the agreement entered into between the parties was in the year 1992, and the petitioner has been sitting tightly for more than 33 years in invoking the arbitration proceedings. Full stop. The allegation of the petitioner that the respondent have inducted new tenants are not established from the evidence placed on record, and this court, and prima facie, this court is of the opinion that no interim relief can be granted to the petitioner, since the petitioner has failed to satisfy the basic ingredients of granting any interim order in their favor. The present application is dismissed.
Grateful to you.
Section 9 FET. FET पेज 176 में है ना, FET नंबर डाल देना, पेज 176.
This is my application under section 9, your lordship.
Yes.
Pursuant to the last order, we had sought to effect the service. I'm carrying the affidavit of service. It shows that it was delivered to Islampur SO. May I hand up the affidavit?
So delivered, not delivered?
Delivered. But that is the last report. So I wish to point that out up front.
Islampur SO. What is this Islampur SO?
As per my instruction, it must be the post office at Islampur.
That can't be considered to be delivered.
That's the issue. That's the issue. That's why I sought to point that out. We have to write to the post office, gather the confirmation, and only then can I say it was delivered, because it shows item received at SO.
All right. So you do that.
Very well. Your lordship will keep it after a week. And in any event, your lordship will also direct substituted service in case, because they have not been appearing in the proceeding. And there has been no reply to any communication either. So in any event, we will effect the substitute service and come up. before your lordship.
All right. Learned counsel for the petitioner seeks and is granted further time to effect service upon the respondent number.
Your lordship,
Respondent number.
I'm the petitioner, your lordship.
Which
Only
respondent?
one respondent.
Respondent. To effect service upon the respondent. Let this matter be listed after 2 weeks.
Very well. I'm deeply obliged.
Section 9 application.
File an opposition to this subject of course.
Yes, I totally agree. So much has happened after the filing of this petition.
Oh, statesman
Yes.
released. Released.
Lord,
I can't
I
hear.
consent, my lord, if
I
my
can't.
lord,
I can't hear it.
I was only wondering if
Statesman matters. I won't hear.
Lord, I am not for statesman, I am the other side, and I am requesting your lordship to
No, no.
take it.
Due to personal reasons, just take down. Due to the present application is. Let this matter be listed before another bench, subject to orders of the Honorable Chief Justice. Sorry, Mr. Chaudhary.
No, not at all, Lord. I would have loved to do it.
I've been their lawyer also, so I can't do.
Yes, Lord. They had operations in Delhi.
Yes, in Delhi they had operations. In fact, they are still continuing in Delhi, but in a much smaller. Here, my lord,
Won't be appropriate.
Yes.
the dispute is.
But
the
I would be
statesman house has-
completely comfortable if your lordship takes it up
I
because
know,
it,
but then
No, no,
in today's times,
you're not rest over here.
I think the bar has more faith in us.
yeah, Lord, how does it matter? 10 years ago, you have decided a matter.
Those days, my lord. In fact, I'm surprised that your lordship still remembers the clients which your lordship has. Statesman may be one, but I may not also don't remember who have appeared for.
Fortunately, I will. I don't want to say that, but my memory is not that.
It's difficult.
It can't make any. I've done one arbitration as an arbitrator, and Lord, I realize that it really makes no difference as to who's the client and who appears.
But I've personally also not.
Yes,
That's.
No,
that's
we don't want to embarrass your lordship.
Oh, 70.
Who's there in 17?
Now 17. From 742 of 2025, Nikki Metals Limited versus Jarina.
So not today, but I'll dismiss in default next time. First day I'm not doing it, but not today.
Number 18.
18, my lord, I appear for the petitioner, my lord. It's coming after, my lord, I have obtained an order. I have served upon the respondents. I'm filing my affidavit of service. My lord, the earlier letter which was also sent, my lord, they have refused to accept service, my lord. So we have served it on their email to all the respondents. Now, my lord, what has been done, surprisingly, after the order was passed, they have inducted a new director, my lord. This was a case, my lord, for money lent and advanced. 10 lakhs rupees paid, my lord. Now we have sought for refund. To which, my lord, they are not, my lord, I was inducted as a director in the company on the basis of a joint venture agreement. Money invested. Now, my lord, parties have fallen out, my lord. Now they are seeking refund, the petitioners. The respondents, my lord, are creating mayhem in every sort manner, my lord. They have ousted me from the emails. Everything has been done. My lord, as an interim measure, my lord, I have sought for deposit of rupees 10 lakhs by the respondents before this court. And my lord, the matter may be relegated to arbitration, my lord. because it's a complete defiance to the earlier order. Your Lordship may kindly sees. I'm just handing this over. I will file also a supplementary affidavit. একটু না জজ সাহেবকে দিয়ে দিন তো। Kindly sees, my lord, this is the MCA portal printout. Item number 1 is a new director inducted after the order.
There's no bar.
My lord, there's no bar. My lord, what I try to say is, my lord, that they are in full knowledge of the order, yet, my lord, they don't appear, and my lord, they do everything what can be done. There was also a direction for them to comply and to provide the accounts, because, my lord, it's a categorical allegation that they're siphoning off with the funds.
So nothing is there. What do you want today?
My lord, I am seeking, my lord, they have not given the furnished the accounts, my lord, which they were directed to do. Even after the communication, they have sat tight. I'm seeking, my lord, an order in terms of prayer, my lord, B, your lordship, of the petition.
Prayer B of the petition.
Yes, my lord, that's at page 19.
Invoke the arbitration proceeding. Nothing is here.
My lord, what they are doing, my lord, they have made me out of the bank
This court
account.
has declined to grant any relief to you.
Yes, my lord, your lordship, that is why, my lord,
The
I
earlier
was
order is very
directed.
clear.
Your lordship, that is why I was directed to serve upon the respondents. After service, I am here before my lord.
That's all right.
Your lordship, that is the interim measure, my lord. They will create everything and, my lord, make my claim redundant. What I'm seeking today, my lord, is, my lord, that this is the subject matter in arbitration.
That's okay. But I'm not going to freeze any bank account.
No, I'm not asking for freezing, my lord. Your lordship, may kindly sees paragraph prayer B at page 19 of the petition. This doesn't ask for freezing of the account. And my lord, I'm not asking this money to be deposited to me, my lord. I'm asking this money to be deposited before the trial, before this court, my lord. This money has been admittedly received by them. Now they will not pay. They will not appear before my lord. And my lord, they'll make me run from pillar to post. I'm just seeking, my lord, that this order may be passed, and my lord, I will proceed with the arbitration. I'm not asking this money to be paid to me.
You have not been able to serve upon them.
Yes, my lord, we have served. The hard copy of the letters they have refused. At, my lord, the last page, your lordship may kindly see that the affidavit of service
Yes.
is service through email, my lord, through which parties were communicating. If they don't accept service, your lordship may kindly sees. If they don't accept service, my lord, physically, I had to serve them, my lord, through email. Despite this, my lord, they are not appearing, your lordship. Your lordship may kindly directs, my lord, for me to serve them again, I shall come. But, my lord, this approach, my lord, should be negated, my lord. That they'll know of the order and they'll, my lord, induct the director. They will, my lord, oust me from the company. They'll not let me operate the bank accounts, and your lordship, they'll siphon off the
Where are
funds.
the orders which are whereby non-bailable warrants are issued?
Non-bailable warrants. Your lordship, I couldn't get my lord. Non-bailable warrants.
Some there are this we'll have it next week.
Yes, my lord. My lord, may kindly directs me to serve, my lord. Once again, my lord, I shall serve so that, my lord, this issue may not.
Learned counsel of the petitioner seeks to effect service on the respondents. Seeks and is granted further time to effect service on the respondents.
Through email and through speed post.
Let this matter be listed next week.
Not just, my lord, one line of direction, my lord. In the alternative, if they don't appear, my lord, I shall be
We'll see that.
grateful, my lord, grateful.
Next. 19. Here appear.
I appear for the respondent number 3.
Yes.
None for the petitioners, my lord.
Who's for the petition? Nobody.
On the last occasion also, my lord, Justice before Justice Shorka, they had not appeared. Lordship, my lord.
First day, no
No,
dismissal.
no, at least the recording be there will that
Tomorrow-
none appears for the petitioner.
None appears for the petitioner. Let this matter be listed after a couple of days.
Right.
दो तीन दिन बाद का डेट दे दो आप डेट 2-3 दिन बाद का डेट दे दो 3 दिन बाद का
It has kept it on Thursday.
थर्सडे
Right.
Lord, I appear for the respondent in this matter. I am opposing this application.
Lordship, I am for the petitioner. Lordship, I am led by Mr. Sudeep Pal Chaudhary. He is not well. He cannot attend today. I am praying for 1 week adjournment. Lordship.
Kindly, my lord, one indulgence, Lordship would kindly record. There is an application under 29A for extension of the mandate of the arbitrator. Now, my lord, we have also filed an application under section 14 for termination of the mandate of the same arbitrator. Now, my lord, in the section 14 court, they are showing the pendency of this proceeding and saying that this proceeding is already pending. So, my lord, kindly records, let the accommodation be granted. My lord will record that no impediment in the hearing of the section. They cannot have it both ways.
all right proxy counsel Miss take down Miss so and so appears and states that the main arguing counsel is in some personal difficulty, full stop. She prays for an adjournment, full stop. Learned counsel for the respondent states that the petitioner is deliberately delaying the proceedings before this court since the respondent had filed an application under section 14 of the Arbitration and Conciliation Act 1996, right? Section 14 application, full stop. He states that the arbitral tribunal is not deciding his application in view of this pending application.
But that is before the commercial court at Rajarhat, not before the arbitrator.
All right. The
Section 14 application.
then क्या लिखा है वो change होगा. He states that he has filed an application before the commercial court
At Rajarhat.
at Rajarhat under section 14 of the Arbitration and Conciliation Act 1996, full stop. He further states that the said application is not being taken up by the said court in view of the pending application under section 29A before this court, full stop. Let this matter be listed. After 2 weeks, when do you want?
After 2 weeks.
And when is your next date there?
10th of November.
10th of November. So we'll have it before 10th.
Very well. Then, my lord, I'll come back.
We'll have it before 10th. Before 10th date. Before, give it on the 7th. 7th.
Grateful.
7th.
Grateful to you.
The 21 is by application under 29A for extension of the mandate. It's an ex parte proceedings going on. They have not filed any statement of defense. The matter is now at the final argument stage, where I have filed I am the claimant. I have filed an application for disclosure of additional documents, which is being considered by the learned arbitrator. It's at the final hearing stage, final arguments. The tribunal was constituted by an order of 15 December 2020 by this court. And during the COVID, it could not take place. And thereafter, the mandate expired because the respondent obviously.
What is the stage?
Final arguments.
Final arguments.
Final arguments. There is also an application by the claimant for disclosure of additional documents, which will be considered by the arbitrator.
Okay.
May I just indicate, the way it has been placed is not the case, What has happened, when the arbitration was going on, the arbitrator in 2022, make the matter adjourned sine die. In between, after the matter was made sine die adjourned, the time has expired. Now, the petitioner says, thereafter 6 month extension was granted. No document has been placed or annexed with the application indicating, that any minutes after, 19th of February. My lord, I can hand over, my lord, the email which has been, my lord, issued by the arbitrator since the petitioner was not interested in proceeding with the matter, my lord. It was made adjourned finite. Thereafter, nothing on record in the at least in the application, my lord, that my lord, the proceeding.
No, but for, one extension has already been granted
My lord,
with the consent of the parties.
I am not appearing. He says at his consent it has extended. Where is that minute? That
But
has
it
not
was
been
extended then, well, on 4th and 5th September of 2021, it was fixed. The next dates were fixed. Thereafter, the parties did not appear. The respondent in any event did not appear because it was being proceeded ex parte. And thereafter, the mandate terminated. And that is why the learned arbitrator held that the claimant may not be interested in proceeding with the arbitration anymore. But the mandate has since expired, and 29A Lordship knows what it covers even after expiry of the mandate.
Taking all these submissions over here, why didn't you participate in the arbitration procedure?
I not participate. So
Why you couldn't participate?
I could not have it.
You are making all these submissions over here, but you could not participate in the proceedings.
I understand, my lord, but today,
How can you even make these submissions?
my lord, this.
You are not even participating in the proceedings over there. And then you come here and you object to the extension.
They have also, my lord, made the.
Why didn't you appear there?
My lord, I had appeared. It is, in fact, my lord, it is my section 11 which was, my lord, given transferred for arbitration.
Why is it ex parte if you have appeared?
My lord, subsequently, my lord,
Subsequently, you decided not to.
My lord, I could not file the statement
Why you
of
could
claim.
not file
They
it?
have filed the statement of claim, and that is why they become claimant.
So why couldn't you file it?
Lord, that instruction.
Because you choose not to.
That instruction I do not have. But the thing, my lord, means there has to be an extension, my lord, for bike. There is nothing on record to show that it was extended 6 months, my lord. They are saying on oath that it has been extended. There is no minutes after 19th February, after the arbitrator.
But even if I take that, there was no extension for 6 months. Even if I take that, accepting my learned
How
friend.
can you make that averment in
No,
the
that is the averment that I've made. It's pleaded in the application.
How
I
have you
also
pleaded?
I
How
also
have
find that
you-
there is no document in support.
How have you pleaded that?
But it's there. It's perhaps my lord, I'm not there in the arbitration, but my lord, but the pleading.
Sir, you can't.
No, I'm not shifting any blame. My lord, I'll have to take the responsibility. The
This
pleading
is
is
your application.
yes. My application.
How
there
have
is
you
no,
pleaded?
well, there,
On what basis have you pleaded?
But well, I'll indicate. Well, after the tribunal was constituted, well, the meetings were held. There was an application filed by me under 25 for keeping the proceeding
Counsel,
the
let me
matter.
tell you,
I'm so sorry, my lord.
if your pleadings
Yes.
are incorrect to the facts,
Yes.
I'll
I'll
hold you for
recheck, but my learned friend has indicated that that there is no minutes. I also could not find any document in
then how
support
have
of
you
that.
said so on affidavit?
But kindly, when it keeps the matter tomorrow, I'll take appropriate
Tomorrow.
instruction tomorrow.
Not today. Come back tomorrow.
I'll come back tomorrow. Great.
Can it be, my lord, day after?
Day after.
Day after is holiday, my lord, Thursday.
Oh, Thursday. Thursday will have to.
My application, my lord, under section 29A
Yes.
for extension of the mandate.
I'm opposing the maintainability of this application on the ground of lack of territorial jurisdiction.
Lack of?
Territorial jurisdiction. Well, the entire cause of action has arisen within the jurisdiction of the Learned Commercial Court at Rajarhat. They have previously filed an application before the court at Barasat, which was transferred
Barred by 2E.
2-1E.
2E.
Two, 3 points. First,
you overcome this 2E.
Yes, I'll indicate.
Once you have got extension from there.
No, section 11 filed by the in this court.
Forget section 11.
Always filed in the High Court.
Section 11, no extensions from any other court. Section 11 filed here, only mutual extension by the parties, and there
You have approached the court below for the mutual extension.
No.
That is my difficulty. In fact, we are consenting to the
No, and there's a coordinate bench judgment that 29A cannot be filed in any other lower judiciary. It has to be filed in High Court. We have a coordinate bench judgment now.
And I also have a coordinate bench judgment at a Supreme Court.
And
judgment, which is now
and 2 or 3 other points.
Wait,
Your Lordship would kindly.
We'll hear you. We'll hear you.
Yes.
Yes.
Kindly seize my section 21 notice, which is at page 25.
Page?
25 of my application.
Page 20.
In fact, my lord, I'll not trouble your Lordship with this. Kindly straight away comes to page 67. which is the order under section 11 appointing the arbitrator.
You can trouble me anyway, but the document which you have placed on record, absolutely ineligible. You can't read.
Well, I'll try and arrange for a better copy, my lord.
Can't read at all. Yes, tell me which page.
My lord, page 67, my lord. Now, this is an order passed in a sections 11 application by this honorable court appointing an arbitrator.
Yes.
Now, the learned arbitrator who was appointed by this order unfortunately passed away on, my lord, 27th of July 2022. My lord, if your lordship is pleased to turn to, my lord, page 71.
This order is 9th December. Huh?
This order is 9 December 2019. The arbitral tribunal entered upon reference. The reference was going on. In the midst of the reference, my lord, the learned arbitrator passed away. Now, the date of death is 27th of July 2022.
Yes.
My lord, will kindly now have a look at page 71, which is the notice after the passing away of the erstwhile arbitrator. Now, your lordship would kindly have a look at page 71 bottom, where, my lord, we have set out clause 34, which is the settlement of dispute clause. Now, if my lord kindly turns to page 72, your lordship would 73. I'm sorry, my lord. Your lordship would kindly see the last paragraph of the quoted portion, just above paragraph 4.
Subject arbitration.
Subject, I'm grateful, my lord. May I place it? Subject arbitration as aforesaid shall be conducted in accordance with the provisions of the Indian Arbitration Act 1996 or any other statutory modification or reenactments thereof, and the rules made thereunder, and for the time being in force, shall apply to the arbitration proceedings under the clause. The venue of arbitration, if any, shall be at Kolkata. This is one of the points. Now, my lord, because there was a death, the learned arbitrator became de jure unable to perform. So, my lord, we had filed a section 1415 application. Kindly takes a look at page 77. Section 15 before this honorable court. Kindly sees the order dated 13th of June. This is an application under section 15 of the 1996 Act. So, my lord, I'll attack the point of my learned senior friend from this point also, from section 42 point also. That A, I have the jurisdiction clause in the contract which says the venue in Kolkata. B, section 11 order passed in by the Calcutta High Court. C, section 15 application disposed of by this honorable court. Kindly takes a look at this order, page 78. The new arbitrator is appointed in place and stead of the deceased arbitrator. Now, by consent, parties had extended the time for a period of 6 months beyond the 1-year period. Now, my lord, will kindly have a look at page 201, which is the last day's minutes. I've annexed all the minutes. I need not trouble your lordship with the remaining, my lord. Kindly takes a look at page 201 and kindly sees the second paragraph. Parties have agreed. Parties, your lordship would kindly mark, my lord. Parties have agreed to file necessary application for extension of the mandate of this tribunal in terms of section 29A of the Arbitration and Conciliation Act before the Honorable High Court, and they will take necessary steps accordingly. So, my lord, even in the reference, my lord, both of us jointly submitted that we shall be filing in the High Court for the extension of the mandate. Now, on this point, the arbitration is now lying stalled because of the pendency of this. হ্যাঁ জানি কোথায় কপি তুলতে হবে যাচ্ছে তোর কাছে কি আছে I am unfortunately not having a printout of the coordinate judgment which I was referring to. If my lord kindly pardons me and permits my iPad to be handed over, my lord, if your lordship kindly pardons me.
I was more used to this digital and the physical.
And I've called for a printout, it's yet to come.
Feels good.
Yes, my lord, I've called for a printout. It's yet
Yes,
to
which
come. My lord.
paragraph?
My lord, paragraph, my lord, 27, if my lord is pleased to take a look at.
Before coming here, it was more digital than paperless court.
Yes. But in fact, before the COVID, but I had appeared before Justice Vibu Bakru's court in 2018.
Yeah, completely.
2 years before COVID. That was a complete paperless court with a
Completely.
yes. And one of the learned advocates couldn't find whether the rejoinder was filed. The honorable judge checked from his device, the system, and said yes, the rejoinder was filed on such and such day. So well, this was that
level.
And that was the first time I saw.
Completely
paperless.
And with all due respect, here we don't even have running pages. We have pages for the writ petitions or
in the opposition. Yes, yes.
affidavit in opposition, then exception or reply, but the running pages are not there.
Right.
So it is never placed in serial, which will assist the court. So it is always you are searching for the papers, which makes it very difficult. No running pages at all.
And but that is the system.
I know.
So that is why possibly to eradicate that, some of the honorable judges had started the practice whenever they are hearing final to prepare a paperbook of all the pleadings compiled. So
Correct.
that solves the
Yeah,
issue
but
a
that can
bit,
only
but
be
it
in,
should have
in big matters, like not in all matters
in
you
all
can ask for a paperwork. Which paragraph? 27.
Paragraph 27, my lord, is kindly pleased to take a look at, my lord, page 19.
The provision section cannot be interpreted to apply in future.
May I place it, my lord? The provisions of section 21E in the context of section 29A cannot be allowed, it cannot be interpreted to allow an inferior court to overrule or undo an order of the High Court. The Parliament could not have ever intended the district court to substitute an arbitrator appointed by the High Court. In this context, the decisions of different High Courts are quoted. Your Lordship may skip those, my lord, and come straight away to paragraph 33, my lord.
No, but this is not the provision which we are talking about. What, Mr. Counsel, probably what you are arguing probably is that 2E.
Yes.
If a person has already approached the court, original side court, wherever it is, the district court, depending on the pecuniary jurisdiction, then the same thing cannot be filed in the High Court.
Under section 42, then possibly. But we have not approached any other court.
That's right. The facts are different here.
Yes.
Yes. Which para?
No, my lord, paragraph 32, my lord. But because your lordship would kindly recollect, my lord, section 21E language starts with the language unless the context otherwise. Now may I place it? I respectfully adopt the conclusions arrived at by the different high courts in this regard and do not agree with the decision in such and such. It is difficult to comprehend how the power to substitute an arbitrator would lie with a court other than the court empowered to appoint arbitrators under section 11.6. For this reason, the definition court cannot be taken in a strictly contextual sense as the context requires otherwise. Then 33. No doubt that once the arbitrator is appointed under section 11.6 of the Act, the court appointing the arbitrator becomes functus officio for the purpose of the arbitration proceedings before the arbitrator. However, that can never take away the power of the court which appointed the arbitrator under section 11.6 to extend the mandate, and such power of extension is not an empty formality. Several consequences may flow from the exercise of that power, including the power to reduce the fees of the arbitrator if the arbitrator is found to be responsible for the delay, substitute the arbitrator, direct the stage from which the proceeding should continue, and also impose conditions and costs on the parties. So these are all the facets which section 29A includes within its ambit. Now, my lord, that is why, my lord, interpreting all the other judgments, my lord, a coordinate bench of this court has, my lord, but our case, well, I need not possibly labor into that issues. A, the jurisdiction clause says it's Kolkata, the venue clause. There is no jurisdiction clause as such. The venue of the arbitration is Kolkata. B, there is a section 11 filed here. C, there is a section 15 filed here. So that attracts 42.
They have already submitted themselves to the arbitration proceedings.
And they have. It's going on. Our witness action is complete. I'm sorry, the claimant's witness action is completed.
I read that order.
And the respondent's witness action would be beginning, my lord. So at this stage, my lord, on these issues, when the...
Anything else? Your argument after lunch.
I'm sorry, my lord, the printout has come now. My lord, may I?
After lunch.
Non-commercial, non-commercial. After lunch, my lord takes non-commercial matter.
Tomorrow?
No, no, no.
Tomorrow. Keep it for tomorrow.
But my lord, in item number 20, the self-same point is involved. So my lord can actually hear both matters analogously if your lordship so pleases. Yes, they self-same point.
We'll have it.
Very well.
Documentary dated 3rd November, item number 1, SECOM 254 of 2020.
Lord, I appear for the award holder.
Number 4, and for the fifth my lordship, he has been brought under arrest. Warrant of arrest was issued against him.
Where is he?
High Court, my lord. In order to release the order.
Stand here.
There was this warrant of arrest against 3 also, my lord. So I do not know whether he has been. What is the report, my lord?
So who's here? Subrata Ghosh.
Yes, sir. I am representing Ashish Kumar.
He's also here.
Yes, sir. He has been brought under.
Respondent number 3 was there was a warrant of arrest.
He's also here. Respondent number 3. Only 2 are here.
Factory and other kind of office that is able to person located.
Yes. You are aware of the case?
To some extent.
What do you mean some extent?
Because
what is the liability?
Lord, the principal amount is 7,57,500 with interest from 20th September 2028 at the rate 7%. So now it's about 11.5 lakhs, my lord.
11.5 lakhs.
A little less than that, my lord. Little less than that.
To be divided between the parties or
no, my lord. This was a partnership firm. The judgment debtor number 1 is a partnership firm, and these are partners. So the liability is jointly and severally.
Jointly and severally.
So if any one of them pays, I am happy with that.
Okay. Yes, you are appearing for number 3. 5.
For 2 and 6, my lord.
Yes.
So I filed the asset matter immediately.
You are appearing for?
I am appearing for 2, 4 and 6. 4 already appeared and they undertake to file their asset matter.
So today it is only 4 and 5 who are appearing here.
4 and 5. And by an order dated 5th of August, they were directed to file their affidavit of asset, my lord.
They have not done. They have not served me a copy, my lord. It was made returnable today, my lord. They have not served me a copy, my lord.
Already 2 has already filed. 2 has already filed. It was served.
6, my lord.
6 will file, my lord. 6 will file, my lord.
My lord, in that case, my lord, let there be a warrant of arrest against 6 because he has not complied. He has not complied. Kindly seize the order of 5th of August.
Comply, my lord. I take some time, my lord.
You should have complied by now.
My lord, within 1 or 2. He is not in station, my lord.
Since August.
He is already filed.
What about 5?
He has been brought under.
5 is here. 4 and 5 are here.
I am appearing for the.
What about 3? Who appear for 3? You appear for 3 also?
Yeah, she is absconding. Warrant has not been executed. Committed with office of police station, my lord. Which itself is closed, my lord. Premises including the whatever it is, my lord.
No, but they should make endeavor to arrest him. Whatever, this is only that
Your
he
Lordship
has closed down.
extends that warrant of arrest, my lord, so that the police authorities can take steps accordingly.
I is concerned, Lordship, I'm undertaking to file the affidavit of asset within 2 weeks from this date.
Why you're not making the payment?
আপনি পেমেন্ট করছেন না কেন সেটা বলুন।
Sir, you know why you're here.
Yeah,
Why you're not making the payment?
actually, I am not fully aware what consequences.
Consequences is you'll go to jail.
I know that, man.
I'll send you behind bars. These are the consequences.
Because my sir, I was residing in the abroad since 2009 to.
Sir, I'm not concerned. Wherever you were staying, whatever you're doing, it's none of my concern. My
Okay, sir.
concern is execution of the award.
Okay. So now I'm ready to compensate all the things.
You're ready to compensate?
Yeah, and declare my assets also.
Declare your assets. Who's the other one? Come on the stand. English, Hindi?
Bangla.
Bangla.
There's an interpreter, my lord. There's an interpreter, my lord.
Translate it. Tell him he has to make the payment.
পেমেন্টটা করতে হবে আপনি জানেন তো, কিন্তু করছেন না কেন পেমেন্টটা?
এটা এই জানলাম তো স্যার, সেটা রেডি করছি, রেডি করে জানার পর এবার সেটা নিয়ে প্রসেস করবো স্যার।
इसे पूछो अभी अभी इसको पता चला है? Did he get to know just now? Ask him.
আপনি এক্ষুনি জানতে পারলেন এটা?
হ্যাঁ, ডিটেলস ওইভাবে জানতাম না, সেরকম কোনো আগে জানতাম না। কালকে যে ঘটনাটা ঘটেছে তারপর থেকে এইভাবে জানলাম।
I did not know the details. I came to know about it.
Bangla, I understand Bengali. So only when I can't speak, I understand. All right, you file your affidavit.
Let their undertakings be recorded, my lord.
Yes.
May I be permitted to file the
Department.
This court wide. Take down. Yeah, take down.
বলুন, আমি শপথপূর্বক বলছি। বলুন।
আমি শপথপূর্বক বলছি,
এই মামলায় সাক্ষ্য দিতে এসে
এই মামলায় সাক্ষ্য দিতে এসে
যা বলবো সত্য বলবো,
আমি যা বলবো সত্য বলিব,
সত্য বই মিথ্যে বলবো না,
সত্য বলিব মিথ্যা বলিব না,
কোনো কথা গোপন করবো না।
কোনো কথা গোপন করিব না।
আপনার নাম?
আশিস কুমার ঘোষ।
ইংরেজিতে বানানটা বলুন।
ASHISKUMARGHOSH।
আপনার বাবার নাম?
দীনবন্ধু ঘোষ।
আপনার বয়স?
36+।
কি করেন আপনি?
আমি প্রাইভেটে সার্ভিস করছিলাম, এখন কিছু করি না।
বাড়ির ঠিকানা বলুন আস্তে আস্তে।
শ্যামবাটি,
শ্যামবাটি,
ধুলেপুর,
ধুলেপুর,
গোঘাট,
গোঘাট,
হুগলি।
আপনাকে 3টে প্রশ্ন করবো আমি, হ্যাঁ, উত্তর দেবেন। আপনি কি কথা দিচ্ছেন যে যখনই দরকার পড়বে আপনি কোর্টের সামনে হাজির হবেন?
হ্যাঁ।
আপনি কি জানেন এই যে কথা দিয়ে কথা না রাখার ফল কি হতে পারে?
হ্যাঁ।
আপনি কি কোর্টের সামনে আপনার সম্পত্তির হলফনামা দাখিল করতে চান?
হ্যাঁ।
Call the other gentleman.
Yeah.
Don't say yes, say yes.
Okay.
Repeat after me. I solemnly affirm
I solemnly affirm
that whatever I depose
by
way of evidence, I shall speak the truth.
I shall speak the truth.
No part of it shall be false.
No part of it shall be false.
And I shall not
conceal anything.
What is your name?
My name is Subrato Ghosh. Subrato Ghosh.
Father's name?
Late Kanailal Ghosh.
Late Kanailal Ghosh. Age? Your age?
65.
65 years. Occupation?
Self-employed.
Self-employed. Residential address?
Ashirwad. B5746 by B5747 by 48. B5747 by 48.
47 by 48.
Yeah. Station Road.
Station
Mankar, pin 713-144, district Purva Bardhaman. Oh, sorry.
Are you giving an undertaking to appear before this
Oh,
court
yes, sure.
when required?
Yes,
Yes. Or do you know the consequence of breach of such undertaking?
yes,
Yes. Do you undertake to file an affidavit of assets before the
yes.
court?
Take down. The award letter number 4 and 5, Mr. So and so has surrendered before the court. Were arrested by the police and have been produced before the court. Full stop. The oath has been administered. Full stop. Both the award letter number 4 and 5 undertakes to furnish their details of asset and undertakes to appear before this court whenever required. Full stop. Learned counsel for the award letter 4 and 5 also undertakes the same, that the affidavit of details of asset shall be filed before the next date. Full stop. On such submission and undertaking, let the award letter number 4 and 5 be released from the custody. Warrant of arrest stands discharged.
Lord, let that be said. Because if they not come, then I'll have to pray for revival, for the revival of the warrant of arrest.
No, I didn't. What are you wanting?
My lord, let that be stayed for the moment, my lord. If they do not comply, my lord, then I'll again will have to ask for the
It
warrant.
has to be discharged. Can't be stayed.
Very.
Warrant of arrest can't be stayed. Yes.
We have already filed another on behalf of the she also. She will appear and file our affidavit of assets as per the order of
The warrant has to be executed.
my lord, he will surrender.
Let him surrender. Let him come.
By the course of this week or next week, that may be recorded that we have requested.
Warrant of arrest issued against award letter number 3 has not been executed. The same is extended. Full stop. Go. Extended for 3 weeks. Full stop. Though the learned counsel for the award letter number 3 assures this court that he shall file his affidavit of asset and remain present before this court on the next date. Full stop. 27th November. Next date, 27th November. Anything else to be recorded?
Lord, respondent number 6 had appeared on the last occasion.
Yes.
He was supposed to file his affidavit of assets. He has not done so.
Learned counsel for just a minute. Learned counsel for the respondent number 6 had undertaking before this court that he shall file his assets Wide order dated 5th August 2025. Learned counsel for the respondent number 6 had undertaken before this court to file his affidavit of asset for award letter number 6. The same has still not been done. Full stop. Learned counsel for the award letter number 6 prays and is granted further time of 2 weeks to comply with the order dated 5th of August 2025. Full stop.
And the Lordship has made it returnable on
27th November.
26, 28, I have some alternative. Anyway, I have proposed to your lordship on scheduled date.
We'll do
If
that.
required, we will fix by your lordship and
We'll
it
do
is
that.
suitable to your lordship and other your lordship.
We'll do
come.
that. We'll do that right now. Just give a date. 24th, we'll give it. 24th.
That is matter of this, your lordship.
Today is the first day.
Yes.
Let me just,
Whatever it is, well, as you like.
let me draw a schedule
Oh,
for
yes.
24th November.
And my lord, it's
Lordship, liberty may be granted to file the Vakalatnama in the department.
Liberty granted to file?
The Vakalatnama.
Yes. On behalf of respond number?
5. And I will file the affidavit of
Liberty is granted to the award letter number 5. Mr. So and so to file Vakalatnama on behalf of respond number 5.
You have already filed on and court.
What you have filed is filed.
Grateful.
Yes. Report, Ria. Report filed by the Deputy Sheriff of Calcutta is taken on record.
obliged.
Grateful. Grateful.
Lordship, I'm appearing for the award holder. 109.
Who's there? Any lawyer? आपका वकील है कोई?
Hindi. I order dated 15 August 2020. Warrant issue.
Yes.
Direction to file the affidavit.
Are you filing?
Oh, today just he contact me.
Just record. ये क्या नाम है आपका?
मोहम्मद कलीम सर।
आपको पता है अवार्ड के बारे में? पैसे कब देंगे?
पैसे सर रास्ते धीरे करके देंगे, अभी तो गाड़ी धोते हैं सर।
दीजिए, जैसे भी देना है.
Lordship, the hypothecated asset is still with him. He has not handed it over.
For that you should have moved an application.
Lordship, we have already a prayer for receiver to be appointed. For
Not
the
in this, madam. You know, you have to move an application. Is this?
हम धर्म से कह रहे हैं,
हम धर्म से कह रहे हैं इस मुकदमे में
गवाही के तौर पर
हम जो कुछ भी बोलेंगे
सच बोलेंगे,
सच के सिवा झूठ नहीं बोलेंगे
सच के सिवा झूठ नहीं बोलेंगे
और कुछ नहीं छुपाएंगे।
और कुछ नहीं छुपाएंगे।
आपका नाम?
मोहम्मद कलीम।
मोहम्मद कलीम। पिताजी का नाम?
मोहम्मद इस्माइल।
क्या करते हैं आप?
गाड़ी धुलाई करते हैं।
कहाँ रहते हैं? घर का पता बताइए।
12H/9
थोड़ा जोर से बताइए।
12H/9 मुंशीगंज खिदिरपुर कोलकाता 23।
जब कभी भी जरूरत पड़े आप कोर्ट के सामने हाजिर होंगे?
जरूर हाजिर होंगे।
जानते हैं इस वचन को तोड़ने का अंजाम क्या हो सकता है?
हाँ जानते हैं। यस।
क्या आप कोर्ट के सामने अपनी संपत्ति का हलफनामा दाखिल करना चाहेंगे?
हाँ यस।
आप तो जाइए, यहाँ पर रहिए।
Just do the same order. That the award letter number so and so has appeared before this court. Same, just follow the same order. Keep the same date also.
अभी तक खाते हो?
24th. All right.
And please give.
Okay.
Please. No.
Any other?
Monthly list item number 426.
Appealing for the judgment debtor, Lordship.
Yes.
And leave to file the Vakalatnama, and I have not received. It's an ex parte award. I have not received the award. I have not received the execution application. I'll take steps, Lordship, but can be discharged upon my undertaking to file the affidavit of assets.
अब पैसे लेते हैं वापस नहीं करते हैं? हाँ,
पैसे नहीं है सर,
पैसे नहीं है तो लेते क्यों हैं?
गलती है।
तो बैठिए आके जेल में। इसे कुछ लेते हैं तो वापस करेंगे नहीं करेंगे?
देगा
तो उसको लेके रख लेंगे घर में।
ना सर, दो सर, आस्ते आस्ते दो,
हाँ,
थोड़ा थोड़ा करके दो सर, अल्प अल्प कर।
घर वर है आपका?
हाँ,
कोई घर है अपना?
हाँ।
अपना घर है? I'll attach his asset.
Yes, I'll give the affidavit of assets. I'll file the rest.
Lordship, in the categorical submission relating to the non-service, Lordship kindly finds the order dated 26th of August 2025. It has been delivered and it has been delivered by the department.
I'm talking about the award.
You have also stated about the execution application as well. Lordship, it is categorically stated in 26th August 2025. This false submission before the court of law is absolutely not acceptable at this point of time.
I'll take steps. I'll take steps accordingly. It's an ex parte award.
Miss the chance to challenge it.
Award dated number 1, so and so, has been produced before the court. Full stop. Both has been administered. Same order करना, so इसमें एक line add कर देना that he states that he has a property. Details of the property. Give the details of the property. So and so, which he undertakes not to alienate, sell, till the award is executed. Give the details of the property.
Actually, I'll file the affidavit of assets.
No, sir. I'll
It's an
say the
ex parte award.
So what?
I have a right to again challenge because I have not been served with the award.
challenge the whatever
Yes,
you have
that
to
is what
challenge.
I'll take steps. The order was
Undertaking that he has a property.
Yes,
I'll record it
yes,
that he has a property and he will not alienate the property till the time the award is executed.
there is no injunction, Lordship.
That's obliged,
Remove
Lordship.
the injunction application. I'll contest that.
That's okay.
It cannot be, Lordship, a suo motu because let them. I'll contest that.
He's giving an undertaking to this court. Who are you?
He's saying
I'm recording his undertaking. He is undertaking to the court that he will not sell the property. I'm recording his undertaking. I'm not passing an order. I'm recording his undertaking. He undertakes not to sell the property. आप property बेचेंगे नहीं?
Sir,
Line add करना. He undertakes not to sell or alienate the property.
sir, दो जमीन बीचे दो sir.
ठीक.
दो आस्ते आस्ते दो.
प्रॉपर्टी डिटेल दीजिए और उसमें आप क्या है प्रॉपर्टी का डिटेल क्या है आपका?
नहीं, जमीन नहीं है थोड़ा.
अभी आपने कहा है आप कोर्ट को झूठ बोलते हैं?
घर है सर.
घर का डिटेल दीजिए. आपकी इतनी हिम्मत है?
की बोलबो?
Take the details of the property.
আপনার যা সম্পত্তি আছে তার হলফনামা আপনি কোর্টের সামনে পেশ করতে চান?
হ্যাঁ.
He undertakes not to alienate the property.
আপনার বাড়ির ঠিকানাটা পুরো অ্যাড্রেসটা বলতে পারবেন?
গ্রাম ছাতারবান্ধি, পোস্ট হাসরা.
ছাতারবাণী।
হ্যাঁ.
उसमें लिखो he states that he is owner of the property, details so and he undertakes not to alienate the property.
Lordship will record my submissions as to it's an ex parte award and
I will record nothing today.
গ্রাম ছাতারবাণী।
File your वकालतनामा.
গ্রাম ছাতারবান্ধি, পোস্ট হাসরা,
তারপর
থানা পারুই.
পারুই।
হ্যাঁ. জেলা বীরভূম,
পিনকোড
731214.
He is giving the plot number. Complete detail दिए? प्लॉट नंबर खसरा नंबर क्या है?
हाँ?
खसरा नंबर क्या है?
খসড়া নাম্বার
খসড়া নম্বর জানেন না তো স্যার? হ্যাঁ?
হতে হ্যাঁ ও তো জমির মধ্যে ও তো জানা নাই স্যার ও তো আমার আব্বা করে গেছিল ঘরটা স্যার বাড়ি আমার বাবা করেছিল
That's okay. What is the plot number? खसरा नंबर क्या है? अरे खसरा नंबर क्या है प्लॉट का?
প্লট নাম্বার বা খসড়া নাম্বার জানেন আপনি?
না
प्लॉट नंबर क्या है?
প্লট নাম্বার কি?
প্লট নম্বর
প্লট নাম্বার জানেন আপনি?
বাড়ির দাগ নাম্বার
हाँ दाग नंबर दाग नंबर क्या है?
দাগ নাম্বার মনে নেই স্যার
दाग नंबर बताओ प्रॉपर्टी का
দাগ নাম্বার স্যার
दाग नंबर बताओ
দাগ নাম্বার স্যার জানি না স্যার
फोन करो पूछो दाग नंबर क्या है
বাড়ির
दाग नंबर दो दाग नंबर दो आप प्रॉपर्टी का
না মাঠের জমি বাড়ি করেছি নতুন
दाग नंबर दीजिए आप प्रॉपर्टी का
আপনি কাউকে ফোন করে জিজ্ঞেস করে
আচ্ছা
বলতে পারবেন তো?
হ্যাঁ হ্যাঁ হ্যাঁ
टेक द दाग नंबर ऑफ द प्रॉपर्टी and learned counsel for the respondent seeks to file his wakalatam on behalf of the award debtor number 1. Liberty is granted. Next.
Lordship is keeping his returnable.
24th.
Much obliged, Your Lordship.
कोर्ट पे झूठ बोलने का पता है ना क्या होता है यहीं से भेजूंगा आपको मैं
नहीं सर झूठ नहीं बोला सर
दाग नंबर दीजिए चुपचाप से
फोन करके
दीजिए अभी नेक्स्ट
Next. The next one.
No. 93. Become 102 of 2025.
102. 102. Last occasion on 29th October, the judgment dated number 2 was arrested and produced before the court. He was released, and she is the judgment dated number 1. What has happened, Lordship? We received a settlement letter, and according to them, they have paid the amount. If Lordship may kindly seize the.
They have paid the amount. Who's for the petitioner? Who's appearing for the petitioner?
Yes, it is actually ECCOM 100.
Oh, I was not informed about this. Lordship, I am appearing for the award holder.
Yes.
May I hand over a copy of the. If she takes instruction and the Lordship may fix another date.
Lordship, I have to take instruction. There is some settlement talk. Later.
Original.
Just take down the award debtor number 1, Suman Singh. Give her the oath. मैडम ये सेटलमेंट हो गया आपका?
हाँ जी
पैसे दे दिए आपने?
हाँ पैसा दे दिया हमने
चलिए ओथ दीजिए
आप धर्म से कह रहे हैं
हम धर्म से कह रहे हैं
मुकदमे में
इस मुकदमे में
गवाही के तौर पर
गवाही के तौर पर
हम कुछ भी बोलेंगे
हम जो कुछ बोलेंगे
सच बोलेंगे
सच बोलेंगे
सच के सिवा झूठ नहीं बोलेंगे
सच के सिवा झूठ नहीं बोलेंगे
और कुछ नहीं छुपाएंगे
कुछ नहीं छुपाएंगे
आपका नाम
सुमन सिंह
पिताजी या पति का नाम
पति का नाम राजेश कुमार सिंह
राजेश कुमार सिंह
हाँ
आपकी उम्र
49
क्या करते हैं
हाउस वाइफ
हाउस वाइफ कहाँ रहते हैं घर का
Show me the settlement.
This is not evident. This is
Settlement.
Oh,
हावड़ा सीपुर दक्षिण अनंतला रोड हाँ
बता सकते हैं क्या आप वचन देते हैं कि जब कभी भी जरूरत पड़े कोर्ट के सामने हाजिर होंगे?
हाँ
क्या वचन को तोड़ने का अंजाम क्या हो सकता है?
हाँ जानते हैं।
क्या आप कोर्ट के सामने अपनी संपत्ति का हलफनामा दाखिल करना चाहेंगे?
यस।
You settle the matter for 500.
That is, they have given, but I do not.
I have no instructions on this, Lordship.
We will all start taking loan from you only.
First of all, I verified the loan account and I found that is also correct.
Lordship, on Friday, judgment debtor number 2 was arrested and brought. Thereafter, there was a direction for filing affidavit of assets. At that time also, they did not say about any settlement offer. But now,
Settlement for 500 rupees for a loan of 14 lakhs. Excellent. We will all take loan only from Cholamandalam. Okay? Take down.
And
The same
judgment
order
debtor
karo,
number
the
2
award
is
debtor
also present.
so and so has been brought before this court by the in terms of the warrant of arrest issued on 29th October 2025. Full stop. She has been administered both. Full stop. She undertakes to appear before the court and shall also file, and she also undertakes to file affidavit of assets before this court. Full stop. वहां ऊपर एक लाइन लिखते हैं ना, warrant of arrest is discharged. The learned counsel for the respondent, award debtor number 1, states that the matter has been compromised and the amount due has been, the amount claimed by the petitioner has been paid. Full stop. The said fact is disputed by the learned counsel for the petitioner. She seeks and is granted time to take instruction. Full stop. Let this matter be listed. Same 24th, on 24th. But you file your affidavit of asset.
Date has been here till 17th November. By that time, I will file. Last okay.
17th November.
Yes, Lordship. My Lordship, may kindly seize order dated 29th
29th
October.
Yes, you file your affidavit.
Let me liberty may be granted to file the wakalatnama in the department.
Learned counsel for the award debtor 1 is at liberty to file his wakalatnama.
Grateful, Lordship.
Hindi.
Lordship 499, I appear on behalf of the award holder.
I appear on behalf of the judgment debtor, Lordship.
मैडम पैसे कब दे रही हैं? कितना लोन लिया था आपने?
सर लोन मेरे नाम पे नहीं था,
किसके नाम पे था?
मेरे हस्बैंड के नाम पे था।
आप को बोरवर हैं?
हाँ
हाँ तो फिर आपके नाम पे भी हुआ ना, को बोरवर है ना?
हाँ तो सर उन्होंने जो नोटिस भेजा वो हमें मिला ही नहीं, ये जो आपके हाई कोर्ट का नोटिस हमें मिला ही नहीं, हमें तो बाद में पता चला है।
ये तो अवार्ड के बाद का है। आप क्या कर रही थी? चलिए आप दे दीजिए पैसे, आप पहले नहीं आपको पता?
सर हम
पता है
बहुत
ना?
गरीब है सर, हम लोग पुराना कपड़ा का बिजनेस करते हैं।
लोन क्यों लेते हैं?
लोन लिए थे सर, वो
लोन लिए हैं तो देना पड़ेगा ना।
हाँ तो वो तो मैं बोल रही हूँ ना सर, उनके लोग भी आए थे तो मैंने बोला था कि हम देंगे, पर अभी जो कंडीशन उस हिसाब से हम धीरे धीरे
कंडीशन
देंगे
है,
सर बोले हैं।
लोन तो आपको देना पड़ेगा।
अब वो तो देंगे सर, मैंने बोला है उन्हें, तो ऐसा नहीं कि बोला कि नहीं को कभी भी वो आए हैं घर पे उन्हें कहा देंगे, पर जो कंडीशन चल रहा है सर अभी इस हिसाब
एसेट
से।
है कोई?
हाँ
घर वर है आपके नाम
नहीं
पे?
सर, अपने नाम पे कोई प्रॉपर्टी नहीं है।
बैंक में एफडी है
कुछ नहीं सर, कुछ नहीं है।
चलिए एनीवे गिव हर द ओथ।
Lordship,
हाँ
Lordship, that loan was taken in the name of the company, Cloth Supply. They're taken and they were the borrowers and co-borrowers.
Let them file the affidavit of asset.
Lordship.
हम धर्म से कह
Don't
रहे
have
हैं
it.
हम धर्म से कह रहे हैं
इस मुकदमे में
इस मुकदमे में
गवाही के तौर पर
गवाही के तौर पे
हम जो कुछ भी बोलेंगे
जो कुछ भी बोलेंगे
सच बोलेंगे,
सच बोलेंगे,
सच के सिवा झूठ नहीं बोलेंगे,
सच के सिवा झूठ नहीं बोलेंगे,
कुछ नहीं छुपाएंगे।
कुछ नहीं छुपाएंगे।
आपका नाम?
सुमन मोहाली,
आपका नाम?
गौतम मोहाली, 34।
क्या क्या पढ़ते हैं आप?
हाउस वाइफ है।
कहाँ रहते हैं? घर का पता बताइए पूरा।
बैंडल, मानसपुर बस्ती। हाँ, मानसपुर बस्ती। बस हुगली। 712123 2123।
क्या आप वचन देते हैं कि जब कभी भी जरूरत पड़े आप उनके साथ
यस, हम जरूर आएंगे।
वचन को तोड़ने का अंजाम क्या हो सकता है?
हाँ
क्या आप कोर्ट के सामने अपनी संपत्ति का हलफनामा दाखिल करना चाहेंगे?
हाँ।
सेम ऑर्डर कर लो। ठीक है। The judgment debtor appears. Oath has been given to him. Discharged. Undertakes to file affidavit. Yes.
Lordship, leave may be granted to file my wakalatnama and
Liberty granted to file wakalatnama. Same as the last order. Done.
Lordship, there's one more matter.
One more. अब वो दाग नंबर दो उसका। दाग नंबर लिखवा दो।
One 116 116
नंबर बोलो।
items 499 item number 3
हो गया दाग नंबर, खतियान नंबर, मौजा नंबर।
आधार बंद आधार बंद नंबर
ठीक है।
আরে এটা কি জিএম নম্বর 29 খতিয়ান নম্বর হচ্ছে 18 57
सीएल नंबर 29 खतियान नंबर 18
ठीक है, जाइए। जब बुलाया जाएगा तो आ जाइएगा कोर्ट पे।
503, ECCOM 125 or 25.
I'm appearing on behalf of the judgment at number 2, Lordship.
क्या नाम है?
সুব্রত মন্ডল।
कितना पैसा लिया है?
18 লাখ টাকা ছিল।
वापस कब करिएगा?
করে দেবো স্যার, আমার একটু বিজনেসটা খারাপ চলছে তো এখন, মানে আমার চালের ব্যবসাটা ডাউন চলছে স্যার, মানে রেশনের চালের জন্য আমাদের ব্যবসাটা ডাউন হয়ে গেছে, ওই জন্য একটু সময় লাগছে, আমি দিয়ে দেবো স্যার।
कोई प्रॉपर्टी है?
হ্যাঁ স্যার আছে অল্প, বসত বাড়ি আছে আমার।
Give him note.
আমি শপথপূর্বক বলছি,
আমি শপথপূর্বক বলছি,
মামলায় সাক্ষ্য দিতে এসে
এই মামলায় সাক্ষ্য দিতে এসে
আমি যা বলবো সত্য বলবো,
আমি যা বলবো সত্য বলবো,
সত্য বই মিথ্যে বলবো না,
সত্য বই মিথ্যা বলবো না,
কোনো কথা গোপন করবো না।
কোনো কথা গোপন করব না। সুব্রত মন্ডল।
সেটিং বলতে পারবেন ইংরেজিতে?
SUBRATAMANDAL।
বাবার নাম?
সন্ন্যাসী মন্ডল। SANNYASI।
আপনার বয়স?
43।
করেন?
আমার চালের দোকান।
বাড়ির ঠিকানা বলবেন?
ভিলেজ হরিপুর, পোস্ট অফিস খলিশাদি, খলিশাদি KHALI SADI, PS হারোয়া HAROA 743425।
আপনি কি কথা দিচ্ছেন যে যখনই দরকার পড়বে কোর্টের সামনে হাজির হবেন?
হ্যাঁ
আপনি কি জানেন এই কথা দিয়ে কথা না রাখার পরিণাম কি হতে পারে?
হ্যাঁ
সামনে আপনি করতেছেন?
হ্যাঁ।
Same order.
Lordship, he undertakes to file the affidavit of assets, Lordship, within. He'll
Affidavit
file-
of asset?
Yeah, affidavit of assets, Lordship.
File it within 2 weeks.
I'll
Affidavit
make it 3
affidavit
weeks,
will be filed
Lordship. 3 weeks.
within a period of 3 weeks. Affidavit of asset shall be filed within a period of 3 weeks. Returnable on 24th.
Lordship, liberty may be granted to
2 weeks. 2 weeks.
2 weeks, Lordship. Lordship, liberty may be granted to file the wakalatnama, Lordship. And can I have the copy of the application from the
Lordship, I'll serve the copy of the application.
at the earliest, Lordship?
May I have your Lordship's kind leave? Lordship, item number 501 of today's list, Your Lordship. Lordship, the warrant is live, Your Lordship, due to our indulgence of not getting the matter listed before. Lordship, the matter has been settled between the parties, Your Lordship. Lordship, the warrant is live due to our mistake. The despite payment, the borrower was taken into custody yesterday, Your Lordship. The mistake was on our part, Your Lordship. If Your Lordship kindly stays the warrant or disposes of the application, we have no claim pending.
Should have moved an application for that.
Lordship, disposal, Your Lordship, we have been. Lordship, these are the 2 orders that has been passed in the matter. Lordship, just I have also given the settlement instruction as well as the list is also there, Your Lordship.
Listed tomorrow.
Lordship, if any direction peremptorily, just so that no
We'll
execution of
list
the
it
order.
tomorrow. We'll finish tomorrow. Is he arrested? I don't think so. That's been executed. He's not arrested. We'll finish it off.
501.
इसको लगा देना, ये 501 ना कल लगा देना, ऊपर लगा देना 501 लिस्ट कर देना ऊपर।
Much obliged, Your Lordship.
598, ECCOM 137 or 24.
I have judgment.
For the
Yes, state your name.
मनोज यादव।
Comfortable Hindi, English?
हिंदी।
कितना पैसा लिया है?
नहीं सर, मशीन लिए हैं, पैसा नहीं लिए हैं सर।
मशीन लिए हैं तो लोन पे लिए हैं ना?
जी।
तो करेंगे वापस या नहीं करेंगे?
तो देने के लिए तैयार थे सर। तो जैसे एक्चुअली बीच में मशीन मेरा माइनिंग में थी हो गया था, तो हम मर्सी मांग रहे थे कि जो प्रिंसिपल अमाउंट है उसको हमको किस्ती करके आप ले लीजिए। 4 साल मशीन फंस गया था उसमें सर, और कहीं से साधन नहीं था हमको देने के लिए। बाकी हम पैसा दे ही रहे थे। एक मशीन यही कंपनी से था, उसको पूरा फाइनल किए हैं, इसका भी पैसा दे रहे थे। और
धर्म से कह रहे हैं,
हम धर्म से कह रहे हैं, इस मुकदमे में गवाही के तौर पर
हम जो कुछ भी बोलेंगे,
हम जो कुछ भी बोलेंगे
सच बोलेंगे,
सच बोलेंगे,
सच के सिवा झूठ नहीं बोलेंगे,
सच के सिवा झूठ नहीं बोलेंगे,
और कुछ नहीं छुपाएंगे।
और कुछ नहीं छुपाएंगे।
आपका नाम?
मनोज यादव।
मनोज यादव। पिताजी का नाम?
श्री ईश्वर यादव।
श्री ईश्वर यादव। आपकी उम्र?
40 साल। मशीन भाड़ा में देते हैं, जो लिए थे उसी को।
घर का पता बताइए पूरा।
गांव बेलाही।
गाँव बिलाही।
हाँ, BELAHI।
बोलिए।
पोस्ट बसरिया। BASARIYA। पोस्ट थाना चौपारण। CHOUPARAN। जिला हजारीबाग। 825406।
अच्छा बोलिए, क्या आप वचन देते हैं कि जब कभी भी जरूरत पड़े आप कोर्ट के सामने हाजिर होंगे?
हाँ।
आप जानते हैं इस वचन को तोड़ने का अंजाम क्या हो सकता है?
हाँ।
क्या आप कोर्ट के सामने अपनी संपत्ति का हलफनामा दाखिल करना चाहेंगे?
हाँ।
Judgment dated 2 is also
Same.
present.
You are appearing for the
Is also present.
स्पेसिफिक कर देना जजमेंट डेटर 1 and 2। जब ऑर्डर करोगे ना 1 and 2 कर देना, 2 का भी वो ओथ कराएगा। आपका क्या नाम है?
सिकंदर कुमार सर।
आपने ये मशीन ले रखा है, साथ ही हैं आप दोनों?
साथ में गारंटर
गारंटर।
हिंदी।
सर बोलिए। हम धर्म से कह रहे हैं,
हम धर्म से कह रहे हैं,
इस मुकदमे में
इस मुकदमे में
गवाही के तौर पर
हम
जो कुछ भी बोलेंगे,
हम जो भी कुछ भी बोलेंगे सच बोलेंगे,
सच के सिवा झूठ नहीं बोलेंगे,
सच के सिवा झूठ नहीं बोलेंगे,
और कुछ नहीं छुपाएंगे।
कुछ नहीं छिपाएंगे।
आपका नाम?
सिकंदर कुमार यादव।
सिकंदर कुमार
सिकंदर कुमार यादव।
यादव। जोर से बोलिए, थोड़ा
हाँ।
सामने आ जाइए। पिताजी का नाम?
त्रिलोकनाथ यादव।
आपकी उम्र?
35।
क्या करते हैं आप?
यही मशीन चलाते हैं।
घर का पता बताइए पूरा।
ग्राम जिरहिया।
जोर से बोलिए।
ग्राम जिरहिया। JARHIHIYA। थाना बरही। पोस्ट केवाल। KEWAL। थाना बरही। BARHI। हाँ, RHHI बरही। जी।
जिला
जिला हजारीबाग।
पिनकोड?
पिनकोड 825405।
क्या आप वचन देते हैं जब कभी भी जरूरत पड़े आप कोर्ट के सामने हाजिर होंगे?
यस।
क्या आप जानते हैं इस वचन को तोड़ने का अंजाम क्या हो सकता है?
जी।
क्या आप कोर्ट के सामने अपनी संपत्ति का हलफनामा दाखिल करना चाहेंगे?
हाँ।
आप क्या करें?
You are appearing for him. Both the liberty to file wakalatnama, praise for 2 weeks time to file affidavit of assets, undertakes to file affidavit of asset within 2 weeks, list on 25th.
My Lord, kindly direct
24th. All matters on 24th.
My Lord, kindly direct one of them to be present, at least the judgment debtor number 1. After, my Lord, I have to examine him after the.
He undertakes to appear before the court whenever required. We'll see that.
So his, after filing affidavit of essence, I would like to examine.
We'll call him for examination. Let him file the affidavit. You see the affidavit, we'll call him for examination.
Let them file affidavit.
That's what the direction is.
Grateful.
All right. Okay. All okay. Thank you. Those are over. Non-commercial एक तो call कर ही लो कम से कम. Please we have.
Commercial matters, item number 1.
My lord, I am appearing on behalf of award holder. In this matter, what happened? The receiver has taken position.
I appear for the judgment letter number 2 and 3.
In this matter, what happened? The receiver has taken position. Asset has, the property has been sold. The receiver has handed over the sale proceed to the decree holder. That chapter is over. Now, receiver was directed to take a step for conveyance of the deed in favor of purchaser. The receiver is taking on that step. My lord, I think that is pending only. I think the receiver has to file a report regarding that. Can you let it appear after 2 weeks? I will inform the receiver, but now the receiver has to inform what the status of the conveyance, my lord.
What I was only praying for, since the property has been sold as per the submission made by the award holder, property is my property. This property was offered for settlement of the dues. Now, as a security for the award, initially in 2018, my bank accounts were injuncted. I was restrained from operating the bank account. Now, since the property has been sold, they will get the awarded sum or this settlement sum. So let my bank account now be made operational. I am not able to carry on my business. This order was passed as a condition precedent so that I am not able to siphon off funds from my account. Now, in the meantime, settlement was arrived at. I have offered the property. That property has been sold. Now they will get the sum, the awarded sum.
Property has been
Now
sold.
my bank account should be made operational now.
That
I
is
should
not
be
a
able
for the
to
full and final
allowed to
certificate.
carry on my business.
There is still due, my lord. Let the receiver has to complete.
Settlement was arrived.
Then we will make some.
Just a minute.
That is
Both the people can't talk.
Yes, correct.
And that is the problem of appearing virtually because you don't know what the other person is saying.
He was not audible. So very sorry. I couldn't hear you.
That's the problem. Virtual appearance.
I understand that. Your lordship, sorry.
My lord, if you go through the order dated, my lord, order dated 24 June 2025, receiver was directed to complete the execution of the deed in respect of the favor. Thereafter, on 4th August, against this matter was directed to appear in the monthly list of November, and further receiver was directed to complete the sale proceed.
Where's the receiver? Who's appearing?
That's why saying, the receiver has to present and say what steps he has taken.
We'll have it tomorrow, not today.
Kali adjourn for a week, I will inform the receiver he has to.
Why 1 week? Why
Yes,
not
sir,
tomorrow?
I will communicate
Let him
to
be
the
there
receiver.
tomorrow.
Yes, madam.
Communicate to the receiver to be here.
Yes, madam, I will do.
Not today. The rest of the matters tomorrow.
Grateful.
Rest of the matters tomorrow. Full court is there. The rest of the matters tomorrow. You look perplexed.
No.
What happened?